For judgment, item 1, matter pertaining to Itanagar bench.
The appeal is partly allowed. The conviction and sentence of the appellant for the offences punishable under section 302, 436 and 201 IPC is set aside. However, the conviction and sentence awarded to the accused appellant for the offence punishable under section 25(1)(b) of the Arms Act is maintained, and the appellant been sentenced for a period of already undergone in custody during trial and after passing of the interim judgment by the trial. The accused appellant shall be forthwith released from the custody jail if he is not required in any other criminal case.
A person who came on deputation at the Debt Recovery Tribunal, at the fag end of he filed an application to treat it as a promotion, and the OA was allowed. The matter is in the hearing list, Lordship, item number 250. Some urgency is there any day after
Item number
250.
215 today.
Hearing list,
That
Lordship.
is the hearing list.
Some urgency is there any day in the first week of May, Lordship. In daily list, Lordship.
Part 2 list doesn't it?
Wait, please, your Lordship. Lordship, item number 31, 52, and 54, my lord. And though this is a series, my lord, there is in separate, my lord, issue, my lord. We are in OBB, my lord, 7076, my lord. My senior is appeared, my Mr. Ken Chaudhary is now in the Honorable Supreme Court, my lord, today, my lord, regarding card hearing today, my lord. So, matter will taken up, May, my lord.
These are all the analogous matters.
But analogous matter, my lord, the issue are different. Some excess teacher, we are in, my lord, you know.
The learned single judges clubbed all those matters and thereafter pass a order in the separate, the questions in the separate category that have to be argued.
Well, all matter were taken up at my lord, May, my lord.
All matters, what about the others?
Others-
Very
I'm
good.
appearing-
For arguing the matter then.
Lordship, Lordship, I'm appearing for this OBB matter.
Attend with the-
Item number,
Wait for your turn. Whenever the notice is called up, we'll take a call.
my.
Wait for your.
Apuna puri work.
Wait, Your Lordship. Lordship, I have filed a writ petition today, Lordship, challenging an order of a DRT, Lordship. Lordship, this matter will be taken up.
How the writ is maintainable?
No, Lordship, because a
You know, the
delay,
remedy of filing an appeal before the tribunal.
Lordship, a delay of 1 day has been rejected on the ground that
Whatever it may be, you have to approach the tribunal.
no, Lordship, there is a judgment of this honorable court itself, Lordship.
There are series of judgment of the Honorable Supreme Court. Wherein they have deprecated this practice of entertaining the writ petitions in the DRT matters or in the securitization matters by the High Court.
If
Series
Lordship,
of judgments.
if Lordship may consider it,
Petition, what are you?
hello.
May I please, Lordship? Lordship, by taking consent from the other side, I beg to mention item number 24. Lordship, here, my senior is unable to do the matter due to his personal difficulty. Lordship, may kindly adjourn the matter for today.
Adjourn.
Please.
Daily list for orders item 1.
Notices for respondent number 1 to 4. Sir, we have 2 PM for answer and 1 left the articles. 3 input, 1 and 3 PM. I think that's. This is not. Because I can. It's neither ready for. He says RTS and it says left RTS. Here address. Here later address. Here after that. They have to ascertain the correct. You have to file fresh notes. because-
Otherwise, yes.
And there is a report that respondent number 1 has already left the RTS.
Yes, your lordship.
So you have to check it and.
Yes, sir.
any other
I'll check up
particular there. Click the notices issued to the respondent number 1 to 4. Remain unserved as per the office report. It is also reported that respondent number 1 has left the RTS. And is not, and at present is not holding the post of chairman cum managing director. When it consent for the respondent, place for and granted time to file fresh notices for the respondent number 2, 3, 4,
2, 3.
and to substitute the respondent number 1 with the present improvement. Just after 2 weeks.
There's a stay order, your lordship. Interim order.
In order, if any, to continue till next day.
Item 2.
No more existence. It is also reported that the respondent number 1 is no more in existence. Having concept in the petitioner raised for substituting the respondent number with the suitable party.
May it please your lordship. I am in possession of a property which was subsequently discovered to have been mortgaged with Punjab National Bank. And I offered to pay the dues of the borrower, my lord. Since I had entered into a contract with the borrower and guarantor to purchase the property, I offered to pay the amount. Kindly come to Annexure 2, my lord, page 22. This is when I came to learn about the mortgage, 9th of January 2024.
It is not yet served. But the respondent number 4. As per the logic. Who is appearing for the respondent number 4? Respondent number 4 is right. It's a study of the respondent number 4. ये मेरा यहाँ नहीं है। Okay. नाइनटीन थ्री का बात करते हैं। Who is the respondent number 4, original owner?
Original owner. We will take press notice, my lord, in case if it has not been served.
Who is appearing for the Punjab National Bank?
No, I am appealing, Lord, and we have filed our affidavit. Lord, in this case, the sale certificate has already been issued long back on 27th of December in favor of,
Sale certificate
yes, issued, my lord,
to whom?
to the auction purchaser. My lord. We have given all the details, and the copy of the sale certificate is also, my lord, annexed.
What it means then?
My lord, kindly come to Annexure 2, page 22.
Yes.
This is the letter issued by Punjab National Bank of 9th of January 2024
Yes.
to the borrower. And it was pasted on the outer wall of the residence, my lord. Now kindly come to the next page, my lord. First page, paragraph 1. You are to repay the amount of outstanding dues with interest plus other charges, cost in full being your liability as borrower to the above loan within stipulated time of 60 days. First page, my lord. So on 9th of January, they are saying that you are to pay within 60 days. Kindly come to next page, my lord, page 23, para 2. You are now informed that the bank is going to possess the secured assets within 10 days from the date of this notice with an intimation to the bank before taking over physical possession of the assets by the undersigned and for its subsequent sale. So sale did not happen, my lord, as on 9th of January 2024. Immediately, my lord, we responded and we offered to pay. Kindly see my representation, Annexure 3, my lord, page 25.
Just.
Respondent number 4 is the auction purchaser.
No,
He is the original owner of the property.
Who is the auction purchaser?
auction
Now they have
purchaser is some other
disclosed
person.
about some other
Auction
person.
purchaser is some other person. We have given the details also.
Newton Saha.
And that is, yes.
We are ready to impede the auction
And
purchaser also.
the sale certificate is also.
By auction purchaser, you are ready to pay the auction purchaser what?
No, we are complete, my lord.
This sale certificate is in respect to the same property.
Yes,
That means the sale has been confirmed.
yes, my lord. On
Title has passed over.
on 27th December.
But my lord, kindly see the conduct of the bank. Bank is issuing notice of 9th of January, my lord.
Mr. Singh,
My lord.
Are you disputing the sale certificate?
My lord, I am relying on Annexure 2.
Whatever it may be.
So I will file affidavit in reply, my lord, because they are now
Then
claiming,
you have to approach the DRT. It's not a matter of Article 226.
my lord,
You
but
have to approach the DRT.
my lord, as on 9th of January, they are saying within 60 days,
What
we
you
are
have
going
said
to.
about this 9th of January order?
No, my lord, the 9th of January, this letter is only regarding vacating the property. The 13th, I have given every document, my lord. Lordship will kindly have page 38, my lord, if your lordship comes, my lord. Page 38 of my affidavit in opposition, my lord. Annexure A. This is the 13-2, my lord. And this 13-2 is dated, my lord, 19/7/2023. On 19/7/2023, my lords, this 13-2 notice was issued, and thereafter, my lords, the possession notice that is under 13-4, lordship will find at page 42, my lords.
the technical issue, as I understand, this is in execution of the recovery plan. So once the property is often shown, but जब confirmation उसके बाद the title passes.
you are relying on a sales certificate
Lordship,
of 27th of December.
Lordship.
You are not disputing this annexure to.
No, I'm not disputing, my lord, because what has happened,
Then suppose if the original that borrower,
Lordship.
he could have paid this amount.
No, he cannot, my lord,
What
because
would happen to this
if
sale?
your lordship will have section 13 subsection 8 of the SARFAESI Act, my lord, after the amendment, the right of redemption of the mortgage, my lord, expires on the date of publication of the sale notice. Previously, my lord, the position in law,
Then why you have issued this notice?
that is so that he vacates the property of his own.
No, you have
The language,
chargeable with full liability as borrower above loan account with the details of the security. Mounting outstanding dues with interest other charges. Being your liability as borrower in the above loan account within stipulated okay, fine.
yes, this is only regarding vacating the physical possession.
The secured cash within 10 days. Yeah, this is a notice.
Notice
They have simply
No, my lord,
stated a fact.
kindly come to
Just
and
they have
page
simply
20
stated a fact that you have not paid the amount within 60 days pursuant to the notice dated on 19/7/2023, and now you have to vacate the position within 10 days. It is not a notice that you deposit the amount so and so, and then your whatever the sale account will be closed, loan account will be closed.
My
It's
lord,
not the notice of this effect.
my lord, what I am saying, at page 23, they are saying that we are going to sell. Now they have taken back, my lord, and saying that a sale has already completed in the month of December. I am ready to pay, my lord. I submitted a representation. Then also they did not
This is
respond.
nowhere mentioned.
My lord, kindly see page 23, para
Yes,
2. I am
yes.
reading once again.
Yes,
You are now informed that bank is going to possess the secured assets within 10 days from the date of this notice, that is 9th of January 2024, with an intimation to the bank before taking over physical possession of the said assets properties by the undersigned and for its subsequent sale in order to recover the above loan. Sale did not happen, my lord.
Mr. Singh,
My lord.
your case is that your client is a bona fide purchaser of the
My-
property without notice,
My lord.
right?
My lord.
Now, what happens is in these matters, once the auction sale takes place and the sale is confirmed, the title in the property passes on to the
Right.
auction purchaser.
I admit.
It is not on the date of sale, but on the date of confirmation of sale. After that, the title can be interfered only on the ground of fraud and no other ground. That's the settled law. That is why the relief you are claiming cannot be granted by the writ court. But if you feel that you have been cheated or a fraud has been committed, you have the option of proceeding against the original owner of the land. Lest you can argue. That's the law, and we'll go
My
by
lord,
that.
I am also claiming, my lord, that fraud, if not only played by the
Good,
borrower
good.
and guarantor, but also by the bank. Bank is saying, as on 9th of January, that we are going to sell. Now they have taken back and they are now saying,
they have mentioned a wrong fact, but ultimately the fact remains that the sale has already been completed.
kindly give me the liberty, my lord, to raise the issue of fraud and then to file appropriate application, my lord.
Whatever it may be, after arguing for quite some
That
time,
liberty, otherwise,
learn concept of the petitioner, learn concept.
With liberty to pursue appropriate
The concept of the petitioner on instructions has submitted that he wants to withdraw this writ petition with liberty to the petitioner to avail appropriate remedy available under the law, raising all the possible grounds as per law.
till, my lord, till a fixed time, my lord, I may not be dispossessed, my lord.
We are
Till
not-
30th of April, my
We
lord.
have withdrawn you have withdrawn this writ petition. We are not going to pass any order this nature.
A limited time of opportunity, my lord.
But
Otherwise, they will dispossess me during Bihu vacation itself.
you avail whatever remedy available to you
Obliged,
by tomorrow itself.
obliged.
The interim order, the interim
The
order,
writ petition is dismissed then.
look, they go and argue in the lower forum sometimes.
They'll, and the lower board will not understand me. What do you mean?
Item 3.
The morning we filed an affidavit in this case, my lord, reply. They filed an affidavit in opposition. We filed a reply. IA for vacating of the order, my lord.
Again, This is again surface matter.
No, that's correct. I know, my lord.
And you have already.
No, no, there are, I will tell you.
And you
lordship.
have already approached the.
No, I will tell you.
DRT.
No, right.
You have already filed an application before
No,
the
that-
DRT after filing of the.
No, your
petition.
lordship is right. I lordship is, that's correct.
Abate your timing.
No, lordship is right. That's correct. I approached, this was prior to that.
Yeah.
Thereafter, my lord, thereafter I advise they go for DRT. So here also we can go to DRT, my lord.
You have already
Yeah.
approached, sir.
No, this property matter we didn't have. There are 13 properties. Out of 13 property, this property, this property we move before this court. Again, this property. But so far other properties are concerned, my lord, we approach the DRT.
So how can you choose two forums?
No, no,
For
that's
one
so.
property, you approach the High Court, and for other properties, you are.
No,
approaching the
thereafter, my
DRT.
lord. Thereafter, my lord. Thereafter, all respect of other property, my lord, we approach the DRT.
Then for this property also approach the DRT.
Yeah, correct. We'll approach it by law. By the, there is an interim order passed by this court.
No, sir, we are not going to extend that interim order. We have already expressed our opinion that Supreme Court in so many
that's
words
correct.
deprecated this practice. That the High Court should not interfere in the jurisdiction in this surface matters.
No, that's
And that is very strong, sir. And time and again, they are. making
only
some
what,
observations.
my lord,
We are
our
not-
case, no, your lordship is right. I am also aware of all the judgments. But what I was on before this court was 13.3 13.3A was not
All the
followed.
possible ground you can raise before
I
the
can
DRT,
raise
and
my-
DRT is supposed to take into consideration all those grounds and then to pass a order.
No, that is absolutely what, that's why they wanted to go ahead without following this became a draconian law under 13.3A.
Challenge the validity of the law.
No,
we
that's,
decide
I will
it.
not challenge it, my lord. How can I?
It's a
Because there is an
draconian
order.
law.
No, draconian law means
Yeah.
all the procedure has to be followed.
So that has been already considered by this draconian law fact is
No,
also within the knowledge of the Supreme Court. Despite that, if they have passed such type of orders wherein they have deprecated the practice and since long, not only recently.
It's
This
like,
consistent view of the.
no,
Honorable
that's
Supreme
a,
Court.
I have seen that 2023 also there are judgment.
Then-
With consistent view has been taken. But that's I'm aware, my lord. It's not that I'm,
So
what I
then
was
how
on.
can you expect, after having knowledge about those view of the Honorable Supreme Court as well as the law laid down by the Honorable Supreme Court, we are going to entertain this.
No, that's not because only principle of nature, my lord, you are aware of. Like, my lord, 13, these are
You
principle of,
Raise all those possible grounds before the concerned court, not before the DRT. And this is not the forum for that, please. This is a consistent view. Yeah. You are withdrawing it with liberty.
well, let liberty to approach by indemnity and some protection, my lord. Because there is a status quo order which has been passed by this court.
Yes, that is there. We are
There is
aware
a
of
status quo order.
that.
And
This
because
application is only for
I-
application of that order.
The status quo order being passed, my lord, by this court. I will approach within 7 days or 10 days. In the meantime, that
Sir,
order will
sorry,
continue,
sir,
my
that- Then it will,
DRT, in other cases, DRT has also given a status quo order.
could be a wrong precedent, sir, and in every
I will
case, the
not- I will-
person will come.
My lord,
Every case, the other day, the person will come, you already passed this order, therefore this, we are not going to attend.
No, that's okay.
Petition withdraw करेंगे ये automatically disqualified.
Okay, after attempting to argue the matter for quite some time, Mr. Das, senior counsel assisted by so and so, on instructions has submitted he wants to withdraw this petition. The court seeks liberty for the petitioner to approach the DRT against the action of the respondent bank. To stop dismiss with liberty as played for. In view of the fact that the petition number so and so has been disposed of, the IA number 822/2024 is also disposed of.
Deeply obliged. Let's say interim order, let the interim order be vacated. The interim order, so that's my lord. That's
The
what we know.
petition has already been dismissed. There is a question of that.
No, normally what happens, you're also right, but normally that interim order passed so earlier, it's also gets vacated.
At that line, Second part, AMI order.
In IA, there is a, that's why.
I understand.
IA is there, that's why. That's I thought.
It's okay.
I am saying against me only, my
Yeah,
lord. I am saying against me.
you could have taken advantage of this.
I don't want, my lord. I know
You've been
myself.
very
my-
fair.
I know myself, my lord. That's why I suggested my client that you should go to DRT and
I don't
accordingly.
think that your client will get any benefit of this after dismissal of the writ petition, benefit of the stay order. That is my view.
No, that's, my lord, let it be, my lord. You see.
Once the writ
And
petition
there
is
are
dismissed
other,
For all practical.
there are other cases where the benefit has been given. I think, I think that they may give a benefit. I
Some
don't
of
know.
the cases
This
may
case,
be, But not in.
this, I don't know what happens. I am deeply obliged, my lord.
For admission, item 4 and 5.
By order dated, my lord, 28/2, your lordship directed the other case to be called on record. Your lordship, please to see our contention was there, that this writ appeal arises out of an order by which my writ petition was dismissed at the motion stage on the ground that similar petition had been filed by the society earlier. Now, the person who was representing the society was no longer the person concerned.
Mr. Das.
He had long been removed.
Mr. Das, you are against the order of the learned single judge on the merits or on the this cost? Against the cost,
Both better.
not both. You choose one. You choose one. Otherwise, we don't find any illegality. Once a writ petition by the same person is filed and now you are coming with that he is not authorized person. Tomorrow again, some other person will come and
No,
say, no,
you-
your
your-
client is not authorized, then we are not going to decide all these things. Sir.
Your lordship, and
Should
that's
have
why,
taken care of that.
that's why your lordship wanted the case record of the other case. Your lordship, please to see at page 68 of this memo appeal.
Yes.
But your lordship, please to see at page 68.
Okay, argue your writ petition. That writ petition number 6854, this is filed by your client.
No,
Then
No,
6854 was filed by the society,
by the society
represented by the chairman.
chairman.
They dispute to say that
That
I was not the chairman at the point of time. I'll address my arguments when it comes.
okay, argue your writ petition which has been dismissed by the learned single judge on merits.
but some other day.
Why some other days? We are ready to hear you on the writ petition on merits. Argue it.
I'm. Some other day, my lord.
Why some other day?
Have.
The only question is that you are operating in the area of another society.
No,
The
I am-
authority has simply asked you to remain in your area, to do the fishing in your area only. That's
No,
all. This is what
fishing-
the question
fishing-
is.
Fishing is permitted, but selling point.
Whatever it may be.
selling point is different.
We don't find any illegality in the order of the impugned order which is under challenge in the writ petition. On merits also there is nothing.
I'm praying we have, but some other day.
The petitioner, appellant, raise some time to address this court on the merits of the writ petition number 729 of 2023. It has been dismissed by the learned single judge by the impugned order.
The connected writ petition stays, my lord.
Stays there.
No, there are two writ petitions.
Yeah, the connected writ petition will be listed
Yes,
along with it.
It would have a bearing insofar as at first point of time, a writ petition was filed by my client as the chairman, if I put it that way. There some order is passed. Subsequently, the same society represented by the secretary by the second.
You are the chairman of the society.
I was at the point of time. What they are saying is that the first writ petition ought not to have been filed. That's their
You
point.
were not authorized to file that.
That's what they say.
Then here, your petition also.
Very well,
merits.
very well, very well.
Yeah.
Obliged, Lordship. Grateful.
get here. Your lordship is fixing a date.
Date may after 2 weeks.
Faster. ठीक है.
Item 6,
May please, your lordship.
वहाँ मैं फॉलो को दिया एपिलेंट से चेक कर ले रिस्पोंडेंट को बोल लगा दोनों का टेंशन है पता नहीं
Yes, madam. My lord, in a number of cases, the Supreme Court's interfered with a disciplinary proceeding where the charges are non-specific and vague. Interfered. And my lord, I will, in a few minutes, my lord, I will give the citation. And also, my lord, in Anand Kulkarni case and Sugat Chakraborty, the Supreme Court held that no delinquent should be subject to the hazards of the disciplinary proceeding if the charges basically are unspecific and vague. Because if the charges are unspecific, it's not possible for the delinquent to defend the charges, my lord. With this, my lord, words, my lord, I say, this is an appeal, my lord, challenging a single judge judgment. And my lord, a single judge, my lord, during the pendency of the writ petition, my lord, state the disciplinary proceeding, being satisfied on certain irregularities. I will also come to them. My lord, the disciplinary proceeding was actually Supreme Court neither allowed nor dismissed the writ petition, but asked me to again appear. The disciplinary proceeding was, my lord, initiated by the impugned show cause notice with 2 charges. Lordship may kindly turn to page 74 of that compilation. Page 74. It will have the very good. Page 74, Lordship. I am, my lord, a postgraduate psychiatric nurse.
Just
পয়সা না হবে itu mu judgment to dia single level saya
Presenting officer has been changed.
that has been said my lord that is not the issue now my lord the appellant
Now, have you attached the copy of the red petition number 2209/2021?
yes
Where is that?
this starts from my lord page 30 34 rather page 34 lordship will find at page 30 page
34 annexure A.
yes my lord that is the copy of the writ petition filed and page 42 your lordship will find what I impugned there. Yeah. Yeah.
So you approached the court in the year 2021, principally with a grievance
My lord, that's
that
what,
they have appointed a presenting officer who could probably a witness in the proceedings against you.
exactly.
That has now been changed.
And also the inquiry officer, who was this overall supervisor.
So
These two
now,
persons I would have cross-examined.
yes, now
Right.
both of those persons have been removed now.
During the pendency removed, so there was also a prayer, my lord, challenging the impugned show cause notice whereby the proceeding was installed.
Okay.
Lordship, kindly have a look at that remain, page 42,
40,
32.
yes,
So those two grievances were met,
42, yeah.
but the hostility was there. 42, no? Page 42, my lord, top. In the matter of impugned memorandum dated so and so containing article of charges against the petitioner. This is what I challenged.
Yes,
And by this memorandum, the proceeding was launched against me. And in the prayer also, I made a prayer to set this aside the proceeding. Now, my lord, I was taking your lordship to page 74. Page 74. And the proceeding was under stay, my lord, till disposal.
yes,
I was taking your lordship to page 74, my lord, kindly have a
70,
74.
74.
Yes, the impugned so called whereby the proceeding was initiated. There were two charges, basically.
74,
Page 74.
yes,
My lord, have a look at this, because I am a postgraduate psychiatric, my lord, nurse at the LGB Mental Hospital at Tezpur. And I was a nursing tutor. Whereas so-and-so, absent unauthorizedly with effect from 26/3 to 5/4, about 10 days. Persuading one or other silly reasons time and again when the nation has been facing pandemic-like situation. It was during COVID. Thus, the act of so-and-so can be constituted as motivated with an ulterior intention, dereliction of duties unbecoming of a so-and-so. This is the first. Then the second, sir, your lordship, see, Rule 20 of the CCS conduct rules, no government sub and institute employee shall bring any political or outside influence in respect of matters pertaining to his or her service under so-and-so. Borua sent several emails directly to the Union Home Minister. This is absolutely on the face of the record. This is not correct. I sent letter to the Ministry of.
sir, we are not here to look into the.
Yes. So the ingredients of.
correctness of the, or truth of the charges. You just, it is for the authorities concerned who has issued a memorandum of charges. You submit your explanation. If they feel satisfied, the charges would be dropped. If they are not satisfied, then certainly they'll proceed further.
So my lord, the question is Rule 20 ingredients are not fulfilled.
Fine.
That is number one.
This is the show cause notice.
Yes, my lord.
You have filed reply to the show cause notice.
I have filed reply to the so cause notice.
And
Then one more
thereafter-
thing happened.
And thereafter, they have issued a memorandum of charges to you.
No, my lord. So there are, as your lordship has seen, there are basically and initially there are two charges. The number one and number two, Rule 20. Rule 20, two charges. I replied, my lord, denying.
Fine.
Then what they did, they gave some additional charges, which is not permissible in the same inquiry.
Fine.
That is also my another limbo argument. Give on page 87, and with all my lord vague and page 87 lordship. Page 88 rather is the statement. Statement of articles, page 88. Kindly now look at these charges and the other two charges which I have shown. These are absolutely new. Only two charges were level. Here it says, Borua could not maintain absolute devotion duty, it's all right. Article 2 is also all right. Article 3, my lord, speaks different thing altogether. Her act can thus be constituted as misconduct for insubordination. Prima facie, it is not correct, absolutely. Insubordination of which authority? Vague and sweeping, non-specific, and it does not attract, my lord, Rule 3, Roman 1 and Roman 2 of the service rules I will show. Ingredients are not fulfilled. Then another new charge, said Biola Borua as a functioning of staff nurse has demanded the institution should provide her conveyance. It is not demanded. I made repeated requests. It was initial period of pandemic, total lockdown. My husband has a car. Please get a pass to him so that he can drop me at the hospital. That was denied. When everybody denied, I waited and they said unauthorized, and that too by, my lord, fabricating the roster, my lord. That is a crucial, my lord, irregularity and hostility by them. They were hell-bent. Then, my lord, kindly see, said Biola Borua, while functioning as staff nurse, has bypassed her immediate supervisor and tried to extort undue benefits. What undue benefits?
That is, they'll show.
Where from?
They'll show.
These are non-specific and these are vague in terms of Anant Kulkarni's case, Supreme Court. I'll show my decision. Then, my lord, kindly turn next page, 89. That so-and-so Borua, while functioning, has been in habit of availing frequent leave. What do you mean by habit? This is not a word in the disciplinary parlance. You say specific instance that you have done this wrong. What do you talk about being in habit? These are outside the parlance of disciplinary proceeding. This word is never found anywhere. So these are the types. It cannot be a legalistic word, my lord. Now they expanded these allegations like this, which is not permissible in the same allegation. In the, my lord, same inquiry proceeding. Then, my lord, what ultimately they did, kindly have a look at 91, the large charge. It will raise my eyebrows, my lord, definitely imputation. That Biola Borua, while functioning as a staff nurse, has been in the habit of availing leave. She is also habit of availing leave before granting same by leave of the service records has revealed that the Biola Borua availed 377 days leave. I would not have been in the job. When? Which year? 2015, 2016. Can this be surge? Now, my lord, I will place my lord, and then kindly see the one document, which is not my document. This is the document of the respondent filed in the affidavit in opposition in my case. I said, while issuing the so-called notice, and you mentioned about certain things, you manipulated the duty roster of mine. Overall duty roster, where my name appears. Kindly have a look at, my lord. 157.
Yes.
157, have my lord, this is a chart. Kindly have a look. That is the official duty roster. They are the custodian of the duty roster, not me. Kindly have a look. At top, it is my name. There are other nurses. The absent period from 26th to 5th of April, it is scratched, cut through. It is manipulated. They couldn't produce the original before the learned single judge. So this is, my lord, absolutely the proceeding is malicious. That, and in my writ petition I stated, I will not take that paragraph to your lordship. Now, my lord, the conduct rule, why the ingredients are not fulfilled, my lordship may kindly have a look at this book as well. Yes. Swamish. My lord, rule 20. Whether it constitutes misconduct. In my book, my lord, it is page 182. I don't know whether rule 20 anyway of the Central Civil Service rules. Because you got it. CCS conduct rules, rule 20.
Yes.
Canvassing of non-official or other outside influence. No government servant shall bring or attempt to bring any political or other outside influence to bear upon any superior authority to further his interest in respect of matters pertaining to his service under the. So ingredients of this misconduct is absolutely, my lord, absent in this case. Where did the political influence, where from it comes? Or yes,
Other outside influence.
outside, no. I simply prayed for leave repeatedly. Leave was in fact granted. I have given the electronic communication. My immediate superior matron, she granted leave. There was a procedure for 50% attendance during COVID pandemic. I have given the ministry circular. So these charges are baseless, my lord, and absolutely, ingredients are not fulfilled. And the other charge, around 9-10 days of unauthorized leave, what they say, I repeatedly said that I have to come work from at a distance from 4-5 kilometers. It's not possible. If you don't provide a vehicle, well, my husband will drop. Lordship, remember the first pandemic in March 2020. No two-wheeler, three-wheeler, even a bicycle was not allowed to ply. So I repeatedly asked my authority. There are electronic, my lord, those are also matters of record. Electronic communication between me. When I failed, then I wrote a letter again to the director, which this time would have copy to the Ministry of Health, not the minister. Can it be termed as political influence or outside bringing in outside influence? Put to page 2. Page 75, have a look. Kindly, your lordship, have a look at page 75. These are the records. I lordship needn't have to go through this. These are the telephonic records. These are mandatory providence of transport was there in the ministry circular. Then this is next page 76. This is the letter. Ultimately, I wrote director. Below, a pass from the institute to be issued from the institute to my husband specifying name, relation, only from Lachit Chowk to the hospital and back home. This pass will be supportive document with my husband in case inquiry by police patrolling party. Then ultimately, sample of the pass I gave, page 77. Look at my bona fide. Then page 78 and ultimately page 79. At that time, these are all online communications, my lord. These are matters of records. Page 79, kindly see. This letter I addressed to the Department of Psychiatric SOD. Copy to the Ministry of Health and Family Welfare for information. Page 79. And they bring in Rule 20, misconduct, political influence.
Yes.
Then, my lord, I will take your lordships to the Kulkarni and the other cases, which I have, my lord, at the beginning, my lord. Let me place, my lord. Kulkarni's case. There is yet another case, of course. Case one. My lord, lordship may take Kulkarni's case, my lord. Supreme Court of India, my lord, is from the Manu, my lord. Anant Kulkarni. Here, lordship may kindly go to page paragraph 9.
Page.
Paragraph 9, my lord. I am taking the 10 copy. Na? This 10 copy I am holding. Paragraph 9. Yes. Quoting Surat Chakraborty, I'll cite next, my lord. Supreme Court 97 held that it is not permissible to hold an inquiry. It is not permissible to hold an inquiry on vague charges. At the same, do not give a clear picture to the delinquent to make out an effective defense, as well be unaware of the exact nature of the allegations against him and what kind of defense he should put up for rebuttal thereof. My lord, the word is, and explain all these things to the disciplinary authority. The word is, my lord, such type of a disciplinary proceeding is not permissible when the charges on their face are vague and non-specific. And no delinquent can defend this type of charges. That is what the Supreme Court said. Then paragraph 10 also, my lord. In this peculiar facts and circumstances, before Supreme Court, it said, thus nowhere should a delinquent be served a charge sheet without providing him a clear, specific, and definite description of the charge against him. When statement of allegations are not served with charge sheet, the inquiry stands vitiated, and having conducted in violation of the principles necessary, that is, evidence adduced should not be perfunctory. Then what is required to be examined? Order. In this case, my lord, Supreme Court ordered for a High Court ordered for a de novo inquiry, which was set aside. But no, you cannot put the delinquent to the hazards of an inquiry if the charges themselves are vague and non-specific. Then, my lord, Kulkarni's case.
Yes,
Kulkarni's case also, my lord. Surat Chandra Chakraborty, my lord, I have given that as lordship, my lord. It's an old case of the Supreme Court of 1970. It was relied by Kulkarni, my lord. Here your lordship may straightway go to paragraph, my lord, 7. Lordship didn't read the whole paragraph. I will refer my two portions, my lord. Beginning, it was said, it was further found that no particulars and other necessary details were given in the charges, and they were vague, resulting in non-compliance with Rule 55 of the Civil Service, Central Civil Service Classification Rules. Next page, lordship. Last few sentences. Next page. Leave about 10 sentences from top. The grounds on which it is in the lower. The grounds on which it is proposed to take action have to be reduced to in the form of definite charge or charges which have to be communicated to the person charged together with a statement of allegation on which each charge is based and any other circumstance when it is proposed to be taken into consideration. In passing, if a person is not told clearly and definitely what the allegations are on which the charges preferred against him are founded, he cannot possibly, by projecting his own imagination, discover all the facts and circumstances. Then below, my lord, last paragraph. The whole object of furnishing the statement of allegation is to give all the necessary particulars and details which should satisfy the requirement of giving a reasonable opportunity to put up the sentence. So there will be basically three for adjudication. Now, one of the issues before both your lordships in this, sorry. So I have brought forward, and this will ultimately be, there will be three issues for both your lordships to adjudicate upon in this writ appeal, my lord. Number one, vague charges. Number two, is it open for the disciplinary authority? If initially you give two charges, I reply that, then you add another 3-4 charges, and all those charges are without any material particulars. Number two. Number three, the ingredients on the face of, my lord, the so-called notice, the ingredients under Rule 20 is not fulfilled. Therefore, it is not a charge. You cannot put me under any inquiry to prove misconduct when the ingredients are not fulfilled. And it definitely the inquiry officers will not go into all these questions of law. They will take it as a charge and then proceed. So therefore, it has during the pendency, my lord, the proceeding was stayed, my lord. Normally, disciplinary proceedings are not stayed, but the learned single judge having considered the stay order, I want to take to your lordship of the learned single judge, what to say? 132. It is at page 133. Heard so and so. Since the very initiation of departmental proceeding have been challenged in the present writ petition on the ground that inter alia attendance sits in respect of the present petitioner for the who didn't go into detail of others. For the concerned period are found to be interpolated, it is submitted that if the departmental proceedings are allowed to continue, writ will be rendered infructuous. The same, however, is objected. Considering submissions advanced, this court is of the view for ends of justice till next date, departmental proceedings shall remain stayed and thereafter it was extended from time to time till disposal. So lordship will adjudicate ultimately this issue.
No, ultimately the learned single judge has simply recorded the argument of the two parties and thereafter in the interest of justice has stayed the proceedings. So what is the point in it?
Yes,
So
I'll
referring to
come.
this.
I'll come to it. I will take your lordship to the learned single judge's order. Having discussed Kulkarni, he didn't apply the ratio. His lordship didn't apply the ratio.
Which ratio?
That it is not permissible to hold an inquiry on vague and receipt.
This is absolutely, sir, and you are at the risk.
No, well, that is what.
Mr. Gonsalves, you are at the risk. Will give any finding regarding the charges here, since you are arguing at elaborately that the charges are prima facie, these charges are make out. Then your only option with you is to go to Supreme Court. Otherwise, go and join the inquiry.
No,
If there any adverse order is passed against you, you can very well challenge it by way of writ petition or whatever the remedy available to taking all available grounds.
My lord, for this poor nurse, my lord, Supreme Court is far away, my lord. That's why I am.
Then you are at the risk of it.
Yeah.
In case we are going to decide against you with a specific finding that these charges are not vague, then you'll have an impact because in that inquiry also.
Learned, my lord, single judge said like this.
Yeah, no, are you? What we have said, you are
I have listened to you. I have listened to you.
you have taken consideration of that, what we have now proposed.
My lord, lordship will adjudicate upon all the three issues that I have, my lord, in my capacity, my lord,
On
limited
merits,
capacity.
on
to forward.
merits.
Then, my lord, the single judge during the pendency of the writ petition, my lord, all along, there is a stay order, let that be there in place.
Mr. Barbara, what the Honorable Chief Justice is saying is that the issues you have raised, at the moment, the disciplinary proceeding is yet to practically commence. Only the presenting officer, inquiry officer now has been changed, and
During the
so it is
pendency.
at a very nascent stage. Now, being a very senior and eminent counsel of this bar, you know that the scope of
I am
writ
still
court,
learning.
the scope of the writ court to interfere at this stage, at the threshold of a disciplinary inquiry is very, very limited. So what my lord is asking is that if these questions are dealt with at this stage and answered in the negative, before Supreme Court, there is no remedy for your client if the inquiry report goes against you and there is a penalty. So do you want to take that chance now? Supposing this court holds that no, the charges are not vague, these are definite. Supposing the court holds that it is permissible to add charges, because even in a criminal trial, charges can be added and altered anytime before the judgment. Only criteria would be whether any prejudice is caused. The person concerned or delinquent must be given adequate opportunity to defend his or her interest. So supposing you have addressed elaborate arguments, after hearing them, we deliver a detailed judgment and assume that the judgment goes against your client. It will be the end of the road for
Then
her.
I will go straight away to the inquiry officer, not to the Supreme Court.
No, that's right. Not this. Even later on, this court, even if you challenge it, the single judge, the DB will be bound by our findings. That's what we are saying. Those grounds will be out for you to challenge when the entire matter. That's right. So will it not prejudice your client's interest? That's what we are saying. Because now only the full view of the matter is not available. You don't know, once you raise this, please, how the inquiry officer will react, whether the arguments will be accepted. It may be accepted, it could be a case of a minor penalty. Anything is possible. But moment the writ court and division bench affirms the single judge's order and gives a finding on all these issues, it will embolden the inquiry officer, and in that event, it will be very difficult for your client to get any kind of respite, any stage before Supreme Court, because this judgment will be binding on these points, even in the single judge. If you challenge the order of penalty, if any, it will be binding even on the division bench. So therefore, before Supreme Court, there will be no respite for your client in the ultimate analysis, if there is an inquiry report against you and there is an order of penalty. That's what we are trying to point out.
Now, my predicament will be, my lord, I go to, suppose after view, I go to the inquiry officer. And he starts conducting. Ultimately, he gives anything adverse against me from 1, 2, 3, 4 alternate punishment, one punishment. It may be dismissal from service, I know, looking at the hostility. But thereafter, I will have to go for a state appeal to the appellate authority, not even directly to the High Court. Then, my lord, I will have to take again these points on the disciplinary. In the Supreme Court, there are two sets of cases. Disciplinary proceeding, when penalty was imposed, one comes before the court, then now we have conducted everything. Even I have brought one, of course, it is very recent by a single judge of this court itself. When this man was, by Food Corporation of India, this man was dismissed from charges with a stigma for future employment. Here, my lord, everything was said.
No, we have understood.
On the ground that the charges were not.
Only question is, so you want an order on merit on all these points?
I expect your lordship to address this, my lord. And ultimately, if your lordship may consider the predicament going there, then again, with the inquiry report and with my dismissal order, I will have to again come and argue all these things again.
That is all assumption. Why are you assuming that there will be a dismissal order, the inquiry report will be against you?
Looking at the hostility, my lord, on their part from day one, my lord. That it is writ large and apparent, my lord, the hostility. They scratched from my duty register. Then they appoint this man.
Would you like to reflect on this query from the court? If necessary, we can have it after Bihu. Would you like to reflect on this? Because this is a very important query and we are concerned about your client's interest.
I would like to address before, precisely, I would like to know the query from your lordship, my lord, after Bihu, what I am to address. I will come prepared.
The query is, I'm on behalf of this bench, I am repeating it again. See, there is a disciplinary departmental proceeding initiated against your client. It is at a very nascent stage. When you came to the court initially, the thrust of your challenge was that the presenting officer will be biased because he is the custodian of the records and he is a witness.
And the inquiry officer also.
Yes, inquiry officer also. Now, those two grievances were genuine and they have addressed it by replacing. Your second ground was that the memorandum of charge is vague. Correct. Now, that part remains open. The single judge says that you should be given an opportunity, 10 days time to respond, and then it should proceed in accordance with law.
Again, repeat it again.
You have been given an opportunity to yes,
by the
single judge, and then the inquiry proceeding to continue. That's the order. Now that order you are challenging by saying three things. First, you are saying that the allegations, article of charges are totally vague. It is no, I am not in a position to reply. But the fact remains that you have already replied. So that ground, you can assess what will be the possible outcome. Number two, prima facie. Number two, you are saying that after serving article of charges, they could not have charged additional article of charge.
Here, your lordship brought an analogy with criminal trials and adding of charges by the police. It is different, my lord.
It's different, but is there any judgment which says it cannot be done?
My lord, in criminal parlance, my lord, as you know, it is the basic principle is proof beyond reasonable doubt. And here, my lord, it is preponderance of probability. There are distinctions.
All right, let's.
Here, my lord, I may be in a very tight corner, my lord. The criminal is open, my lord.
No, that's all.
The investigation, initially, my lord, the victim didn't die. Subsequently succumbed to injury and murder cases.
No, that's all right. It was just a passing reference.
From 304, it comes to.
So the query is, if
it
you
may not be permissible here.
right. So if you want to argue these points and if the court rejects your arguments, that's the end of the road for your client. Do you want to take that risk?
I'll leave it to
Or
your.
do you
lordship.
want to reconsider it again and come back after Bihu and tell us?
I'll come back after Bihu.
Because,
But one thing, suppose lordship sends me to the disciplinary authority, I will have to go.
Mhm.
It has, why the Kulkarni case and Sarat Chakraborty said that don't put a delinquent, it is not a matter of joke for facing an inquiry for 2 years, 1.5 years. It is a hazardous procedure for me. Don't put them. If it is not permissible, if the charges are big. That ratio, your lordship will, I will still press for that ratio.
All right.
Fix it up. Need it.
No, it is purely up to you. If you want to conclude today also, you can do it. If you want a little.
Both way also, if my retable is rejected, I will have to go. And definitely I may expect to get certain.
What we are concerned is that we should not make any observation which creates any kind of problem for your client in future.
Learned single judge has said so.
That's the only thing we are.
Learned
concerned.
single judge said so. They give him give her all opportunities available under the law, available under the pen. But I'm still agree because provided the interim order was vacated, and I'll again have to be put in the hazards.
You would like to take some instructions on that? You want the matter to come up another day?
Yes, my lord, lordship.
When would you want?
But meanwhile, my lord, I have a letter asked by the inquiry officer asking me to appear on 12th of April, days before Bihu, my lord.
No, we
They are
have
not
it before
strike.
that.
Lordship.
You go and appear, what's the remain that, but
Babala,
you want to complete your
suppose you're-
instructions on this point?
No, my lord, suppose you're,
Bicycle color.
that way, my lord, my petition, appeal will be in first. Suppose I go there and appear and start there.
22nd April, 22nd April, 22nd April.
So till that, my lord, I may
No,
not appear.
no,
my
we
lord.
are going to pass any order, no, otherwise if.
That
you
is
want
only natural.
know that maybe you may go and tell him, ask some time, 22nd of April.
Lordship, may I fix the date, my lord.
Yes.
22nd April, let me consult for the petitioner. There's some time to complete his instructions.
Appellant.
Appellant, there's some time to complete his instruction, complete instructions.
Well-
What's, there's some time seeking instructions from the appellant.
Lordship, may I fix a date, my lord?
22nd April.
My lord, can it be on 25th Thursday, my lord? Thursday, my lord.
Well-
My lord, I might have to go for another case out of this.
25th.
24th, my lord, Thursday, 25th, my lord.
24th,
4th will also do.
24th of April.
Item 7.
Wait, please. This appeal is directed against an interim order, which your lordship will find at page 113. Lord, with greatest respect, my lord, the honorable single judge has not even recorded a prima facie satisfaction for passing away the interim order. The balance of convenience has been entirely ignored. If your lordship kindly comes, the order starts at 114. Till almost the end, the submissions are recorded. And thereafter, simply, my lord, at 116A, the learned single judge says that list this matter along with WBC number so and so on 4424. In the meantime, the respondent shall file affidavits, etc. In the interim, state respondents are directed not to issue any license. Whereas, my lord, the license was already issued, not.
Where is the NIB?
NIB is at page 38. There are two clauses that are relevant, which are at page 45. NIB starts at 38.
Page 45,
Page 45.
which are those sections?
Clause 2.1.
Yes.
Basically, the tenderers are required to furnish 3 years.
Read.
And individual, a partnership firm, a limited liability partnership, or a company registered under the Companies Act or subsequent enactments who has proof of filing income tax returns for the 3 financial years out of the last 4 financial years, 1920, 2021, 21-22, and 22-23, duly certified by a chartered accountant is eligible to participate in the bid. Now, if your lordship kindly turns to
Next,
page 47, clause 2.8.
yes.
The bidder should have positive net worth in the preceding 3 financial years as on 31st March 22. And how he is supposed to establish this, your lordship will find at page 51. Clause 6, your lordship will find the page 51. Towards the middle, your lordship will find the documents that the tenderers are required to submit.
Clause,
Clause 6,
documents and comprising the bid.
my lord. And clause 6.2.5, how they are supposed to establish their financial credentials is like this one. Copy of income tax returns along with balance sheets for the years 2019, 20, 2021, 21, 22, 22, 23, any 3 years in sequence, and statement of net worth as certified by the chartered accountant. So what the petitioner had done was he had submitted an uncertified document. And that is how, in fact, there was another clause on ground on which his bid was rejected. They were supposed to mark the technical bid. Hard copy, they are supposed to submit it separately, and they are supposed to mark it as the technical bid. That he has not done. That I will not urge too much. It might be a little hyper-technical ground. But this particular ground is to verify the financial credentials. And he not having submitted, when the tender committee made the assessment, what does I do? The comparative statement. If your lordship kindly turns to the comparative statement at page 93.
Yes.
If your lordship kindly turns to the comparative statement at page 93. Your lordship will find the writ petitioner's name, writ petitioner respond number 1 here. He is Dinesh Mili towards the right hand, second from extreme right, my lord. Is the Dinesh Mili.
Just a minute. Dinesh Mili, yeah.
Now, the second serial number 2, if your lordship sees, whether the envelope is marked as hard copy of technical bid, hard copy of technical qualification, etc. Your lordship will find no.
Yes.
Then your lordship comes to serial number 4, whether the financial bid information submitted along with hard copy of technical bid, etc., etc. Again, no. And then there's serial number 7, court fee. No. Now, based on these, his bid was rejected. And this was as far back as on 16th of February. Thereafter, my lord, after evaluation of the technical bids, the financial bids were opened. I was issued the letter of acceptance on 19/2, which your lordship will find at page 120. This letter of acceptance was issued on 19th of February. After that, I made the deposit of 14.5 lakhs odd, which your lordship finds at the next page, page 121. And thereafter, my lord, the license was also issued, which your lordship will find the original is at page 119. We have given a type copy at page 116. And the learned single judge has, one of the greatest respect, ignored all these relevant facts. And the prayer made in the writ petition is very interesting. He is challenging merely his rejection of the bid. And he is saying that there should be a fresh statement. And without even questioning the validity of my bid. And all these aspects were ignored, and my lord.
So financial bid was opened and license was issued to your client.
Yes, my lord. And without even a prima facie satisfaction being recorded, not to speak of the balance of convenience. Well, just one line interim order has been.
For the other side.
My lord, I am appearing for respondent number 1, my lord. The matter was listed on 15/2024, and the learned counsel for the appellant did not inform the honorable court that the license has already been granted. And the matter was reposted again on 4/4/2024. The interim order was extended till disposal of the writ appeal and the writ petition. And the writ petition is fixed on 24th of April. My lord, my tender has been rejected merely on 2 grounds. I did not mention as hard copy, and IT return was not certified by chartered accountant. My lord, in respect of Tinsukia district, they have
In respect of?
Tinsukia district. In respect of Tinsukia district, the excise department has taken a different views, stating that IT return is not required to be submitted by the chartered accountant. And therefore, learned single judge asked the excise department to clarify which stand is correct. And therefore, both the matter was tagged, and the matter will be heard on again 24th of April and directed to clarify their stand on 24th. My lord, page 51 clause 6.2.5. There is no requirement of submission of IT return duly certified by the chartered accountant. 6.2.5. So therefore, the learned single judge wanted to interpret it. Yes, page 51, page 6, clause 6.2.5.
6.2.5. Just.
Copy of income tax. Yes, madam. Along with the balance sheet for the year so and so. And there is an statement of net worth as certified by the chartered accountant.
So,
my lord, to my understanding, income tax return is a computer generated copy. There is a barcode, QR code. Everybody can check, my lord.
it's
And statement of network as certified by the chartered accountant. Only in respect of network certificate to be certified by the chartered accountant. This is the interpretation as per my understanding.
What about this?
Yes, my lord. I have submitted all the documents, my lord.
Just a minute. What about this? Clause number? This 45, page number 45. 2.1.
Yes, my lord. An individual at partnership firm, an initial liability, my lord. Then page 45.
45?
Yes,
2.1.
yes, my lord. An individual, a partnership firm, a limited liability partnership, or a company registered under the Companies Act 1956 or subsequent enactment of the so-and-so proof of filing income tax return for the 3 financial years and of the last 4 financial years and so duly certified by chartered accountant is eligible to yes participate in that bid. My lord, yes, my lord, the same aspect has been waived in respect of Tinsukia district. Yes, my lord. They have accepted that tender.
If that is,
Yes, my lord.
that is the condition,
Yes, ma'am.
and if they have waived it,
Yes, ma'am.
certainly some person will challenge it.
My lord, then my lord, 19.2, clause 19.2, page
Yes,
60.
yes,
19.2, that tender,
19.1 also.
yes, my lord.
Then
my-
read 19.2.
No deviation in the form and condition and the bid, yes, my lord. So, accepted,
Shall be accepted.
accepted.
This is the
Then-
first.
Yes, my lord. Then 19.2, the tender bid committee overseeing the bid reserve the right to waive minor irregularities, my lord.
How can you say it's a minor irregularity?
My lord, they have
It's the
already-
Eligibility qualification.
My lord, they have already waived in respect of Tinsukia district.
Why have you waived this in Sinjia district?
Yes, my lord. And therefore, both the matters were taken together and to directed the authority to clarify which one is correct. As
Yes, Mr.
But what has happened, that this is a district-wise tender process. So every district committee is an independent tendering authority as far as this process is concerned. So in respect of Tinsukia, since the district committee of Tinsukia, there in one of the cases, they had decided that this was not a mandatory condition. Since this is an online document,
What is the stand of Excise Department?
the department has not yet filed their affidavit in that case because
But what is your stand?
the stand is that since the tender conditions are as they are, your lordship, they cannot be waived. But in that matter, the tendering authority had decided to waive it, and that was stayed by this honorable court. There's a stay operating there.
That has been stated.
That has been stayed.
This waiver part.
This waiver, we had decided to waive it, that has been stayed. The stay is operating.
Stayed.
we'll file a PDB, my lord.
In any case, it is their right to waive.
Yeah.
You are seeking a mandamus directing them to exercise their right in your favor.
It is a district-
Is it permissible?
Authority is the best judge to decide, my lord. If
Okay. Anything else?
So therefore, I may be allowed to file affidavit, I think that's them, my lord.
You may be allowed to.
I will file affidavit, my lord,
Okay.
because they have made a statement that the learned single judge was informed regarding issuance of the license, but it was not
This
correct.
this appeal is filed by the petitioner being agreed with the order dated 15, appellant being agreed with the order dated 15/3/2024. Whereby, while issuing notices to the writ petition number 1516/2024, the learned single judge has passed an interim order directing the state respondents not to issue license to the respondent number 8 pursuant to the NIV dated 14/11/2023 till the next returnable date. Learned counsel for the appellant has submitted that as a matter of fact, the license in favor of the appellant has already been issued on 14/3/2024 for operating a liquor shop. It is further submitted that the appellant has deposited the amount of rupees 14,55,000 with the Excise Department. Learned counsel has further submitted that the learned single judge, without recording any prima facie satisfaction that the action of the respondent department of cancelling the bid of the respondent public petitioner is is liable to be interfered with as passed the interim order restraining the respondents from allowing the appellant to operate the liquor shop pursuant to the license issued to pursuant to the license issued, full stop. Because further submitted that the Excise Department has rejected the bid of the respondent oblique petitioner since he has failed to fulfill the conditions of the NID. And the concepts of the respondent petitioner has submitted that at the time of passing of the order dated, impugned order dated 15/3/2024, the counsel for the appellant has not informed the has not informed the court that the license has been issued in his favor on 14/3/2024. It is also submitted. The matter is now fixed for final disposal.
No, for exchanging of pleadings.
The next date in the matter is 24th of April 2024. And on that day, the 24th, therefore, there is no point in vacating the stay order passed by the learned single judge. It is also informed by the learned, it is also argued by the learned counsel for the respondent petitioner that in Tinsukia district, the district excise officer has waived the condition of filing the income tax returns duly certified by the chartered accountant. And therefore, the respondent petitioner is also entitled for the same treatment. Full stop. Learned counsel for the Excise Department has submitted that it is true that in Tinsukia department, the concerned excise officer has waived the condition of filing the income tax return duly certified by the chartered accountant, but the stand of the Excise Department is that the term, the condition of furnishing income tax return duly certified by the chartered accountant is not liable to be waived. Full stop. Taking into consideration the submissions made on behalf of the parties, we deem it appropriate to direct the respondents. We grant time to the respondents to file their counter affidavit to the appeal. However, in the meantime, effect and operation of the order dated 15/3/2024 shall remain stayed. This in the second week of May.
May I point out one aspect, my lord, as per their license, my lord, annex to page 116, that is valid up to 31st March 2024, page 116. Yes.
Item 8.
Appeal, your lordship. Lordship, in this matter, I have filed an additional affidavit bringing the OA and my lord rejoinder relied on cap, my lord, which is not on record, my lord. My lord, I'm pleased to take up the matter up to 1 week.
And the concept of the appellant is submitted that some additional documents have been filed on behalf of the respondents, on behalf of the petitioners through additional affidavit. So, however, the same are not available on the court. List after 10 days, the registry is directed to place the additional affidavit on the court.
Deeply obliged.
Item 9.
Make the judge. This petitioner is a registered society method. They have engaged themselves in opening medical colleges
etc. in the rural area. Here, my lord, it's already provisions of the
This condition of depositing the security deposit can be waived. How it can be waived?
Parliament.
The condition of deposit of security deposit can be, how can it be waived?
Not that, my lord, only, my lord, similar central government enactments. I have said, said here, my lord, that means your lordship will see 13.
30.
No, my lord. 13 years, my lord. At least one is Dental Council of India Act, and other is, my lord, Veterinary Council Act, and the other is, my lord, obviously, Medical Council. So these, they only want bank guarantee. We are ready to give the bank guarantee, equivalent to the amount they are setting. But in case it is very difficult.
You should not miss.
Right.
And then. So putting appearance on behalf of, you are appearing on behalf
Of the AICTO, respond numbers 1 and 5.
1 and
1 and 5 years.
what about the others?
1 and 3, only 1 and 3 years.
What the deal?
What about 2, 4 and 5? Yeah, you should notice.
4 and 5.
So and so put in appearance on behalf of the respondent number 1 and 3, let notices be issued to the respondent number 2, 4 and 5. Returnable. After 3 weeks. Requisite to be filed within a period of 1 week, just registered daily.
Oblige.
Item 10.
May it please the lordship. Lordship, we have filed a joint application, it's come on record as an IA for appointment of arbitrator on 11/6.
Is that joint application?
Yes, madam. IA 1083, man.
The panel. Where is the panel of arbitrators? Do you agree on any,
My lord, we have agreed on H.K. Sharma, Lord,
agreeing on?
former Justice H.K. Sharma. His name is not there in the 8th August.
No, but they are in full-time employment. We don't know. He cannot function as arbitrator.
My lord, done.
We have not included anyone who's in full-time post-retirement assignment.
Again, put the list, you check it. Any person from this list?
Yes, sir.
Panel of arbitrators.
Yes, another official.
MK Sharma or HK Sharma?
H.K. Sharma.
HK Sharma. He is Upalupayat.
Yes,
Post-retirement, full-time. They are practically. इनको मना करना
Yes,
Lordship, from the list, Justice here, someone name can.
All right. Much number of the list one did not. We'll record that there is agreement on this one.
Item 11.
Notice to the respondents, returnable.
My lord, notice has already been issued and
When?
service is completed.
As per the office of service upon the respondent is complete.
My lord,
Okay. Not, anybody is appearing?
my lord, my learned friend is appearing for the department. Nobody is appearing for the private respondents.
Let me be listed for admission, then.
My lord. It is listed for admission today, my lord.
Only for admission.
Admission, my
What else?
lord. List for hearing.
We'll admit a list for hearing or what else we can do.
My lord.
Okay. In response to the show cause notice, none has appeared on behalf of the private respondents number 5 to 21. Full stop. Mr. So and so put in appearance on behalf of the respondent number 1 to 4.
1 to 4, my lord.
1 to 4. Full stop. Having heard the learned concept of the parties and after going to the improved order passed by the Central Administrative Tribunal Guwahati bench. We are of the view that matter requires consideration and admit to notice learned consent accept notice on learned consent so accept notice on behalf of the respondent number 1 to 4. Let notices be issued to the respondent number 5 to 21. Returnable 6 weeks.
My lord, my lord, notice has already been issued as per the Lozima code.
Admission notice, that was a show
My lord.
cause notice, now admission notice will do.
My lord.
Otherwise, anybody
My
will
lord.
come and say that the notices have not been issued for admission, then it will be understood that now the matter will be heard.
My lord. May I pray, my lord, since my lord, there was a rampant irregularity in the process of selection, my lord, observation, my lord, regarding my lord, the promotion of the private respondent is subject to outcome of this.
In the course order, otherwise also it would be subject to the.
My lord, otherwise, my lord, at the time of hearing, some difficulty we have faced. That observation may.
Of the respondent number 5 to 21.
My lord.
However, it is made clear that promotion extended promotion given to the respondent number 5 to 21 shall remain subject to the, this is an outcome of, this is shall remain subject to outcome of this petition.
My obliged.
Item 12.
Your lordship, I am appearing for respondent number 2 and 3, lordship. Instruction given to the lordship.
Yes, what steps you have taken?
Yes, lordship, I send the documents to the authority, lordship. Now election.
What steps the authorities concerned are pursuant to the district magistrate?
Yet to receive the instruction, lordship. I am very sorry.
Yet to?
Receive the instruction, then the instruction.
Madam, it's 1/3/2024,
Lord.
almost 1 month and still you are not, you are in.
Yes,
list of
I am very sorry, lordship. I shall obtain lordship after being.
Who is the person that who has to respond?
2 and 3, lordship.
Lordship, I am representing the private respondent number 4 actually.
We are not concerned with you.
No,
We have
the-
asked the respondent number 2 and 3 that what steps they have taken pursuant to the order passed by the district magistrate on 24/7/2023. Why they have not responded till date?
Lordship, I need to ask them, lordship. Let
Madam,
it
then
be.
what you are doing
Immediately
till
after
date? 1 month has passed and still
I am very
that
sorry, lordship.
order is
I-
July 2023. They have not complied with. We granted you time.
I apologize, lordship.
Lordship,
After vacation, Lordship, I definitely come up with instruction. Lordship.
Lordship, may I please actually? Actually, I am implement as exponent number 4 actually. I want to give some objections, but copy has not been served.
You want to give what?
Objection of this matter.
Objection of what?
Objection because I have not received anything as of now.
It is only simple case that the district magistrate has passed an order
Yes, my lord.
directing the concerned authority to take action under section 13 of the securitization Act for the purpose of taking possession of the property.
Right, right. I
And
do
their grievance is that he has not taken any steps further.
But here, the cause is that 2 times permission was given. DC asks us to pay the full amount. We have paid the full amount. So
Yes, simply.
that's why my lordship, since I have made a party, I may be allowed to give my objections because I'm.
You are not in receipt of what?
Yes,
You are not in receipt of what? You
anything
are
from
not in
the
receipt of this
copy,
petition.
yes, of course. I have not got anything as of now. Only on the 31st of this March, when the bank called us for some compromise proposal, then only the bank said, "Ki, we had filed a case against you in such and such court." Then only we came to know. 31st of March.
A copy of this.
Lordship.
Okay.
And please
On-
allow us to give us this one, objection.
Counsel, learned government advocate Assam. Yeah. Submitted that. She is not in receipt of any instructions from the authorities concerned. And therefore, the authorities concerned, though this court on 1/3/2024 has specifically directed her to complete instructions as to what steps the authorities concerned have taken pursuant to the order passed by the district magistrate Kamrup Metro on 24/7/2023. She prays 2-3 days time to complete her instructions. Full stop. Learned counsel for the respondent number 4 has submitted that he is not in receipt of the copy of the writ petition and therefore prayed that the counsel for the petitioner be directed to supply him the copy of the writ petition. So, this matter on 22nd of April 2024. In the meantime, learned counsel, learned counsel for the state of Assam may complete her instructions and the counsel for the petitioner may supply the copy of the writ petition to the counsel for the respondent number 4 during the course of the day.
Yes.
Supply him the copy today.
Lordship,
Yes, sir.
one more prayer, Lordship, respondent number 1, there is standing counsel of revenue department, Lordship, there.
Whatever it may be, you complete your instructions in respect of.
Item 13.
Then we may think personally.
And by the next date, if you have not been able to inform about your instructions, we'll call them immediately on the very same day.
Lord.
Mind it.
Lordship.
May it please your lordship. Your lordship may kindly take note of the order in the IA 1517 of 2023. The order dated it's 8/6/2023.
What's that order?
But that order seeks to implement Assam Rajiv Gandhi University of Cooperative Management, Jaisagar as party respondent number 5. Now, this institute where this petitioner, the appellants were working, now it has been taken up by a state university. A state university has been formed under the Assam Rajiv Gandhi University of Cooperative Management Act to 2010. So now the government has a deep and pervasive control over the affairs of this institute also. So my argument is that, my lord, or my contention is that these persons are working in the institute from 2012 without salary. In the meantime, one of them has died, and this honorable court allowed the substitution by the legal hires. That is number one. So for the second and third, one is working as a storekeeper and the other as a chokidar. Now in 2024 also, they are giving funds for running the institution, but they are not giving it for the salary. That's why this petitioner or the appellants are not.
The learned single judge has dismissed your writ petition on the ground that you are not the employees of the state government.
Well, if your lordship, on the last occasion, they have given a judgment to show that it is not an instrumentality of the state.
Yes.
But our contention is that now it is under the Rajiv Gandhi.
Now you claim now.
No, this was considered in 2010, my lord. They did not bring it to the notice of the case. In the judgment, my lord, if I'm not wrong, in one of the submission of the government council, it has gone under Rajiv Gandhi Open University. The paragraph number 10, my lord.
Yes.
My lord, in one of the paragraph. Paragraph number, sorry, my lord, 16. I'm sorry. Paragraph number 10 was the submission of the petitioners, and paragraph number 16.
Yes.
Mr. P. Larner, Standing Counsel for the Finance Department, Government of Representative Respondent, while referring to the affidavit number 5 on behalf of the respondent number 5, submits that the role of SUs was for implementation of so and so, so and so. However, with the establishment of Rajiv Gandhi University of Cooperative Management, Arugam, this was established in 2010, my lord, and they have taken over the minister. Paragraph 16.
Which page, Mr.?
My lord, internal page, it will be.
Forget what is the running page?
My lord, this was given last time, I think, read appeal number 5 of 2022.
You are referring to this impugned order or?
No, my lord, on the last occasion, this court has furnished this copy to us.
There is a judgment of a coordinate bench of this honorable court.
They were trying to rely on.
Upholding of, my lord, the order passed by the single judge that the writ petition is not maintainable. This is Amarjit Burman's case, my lord, read appeal 5/22. And this judgment has been rendered on 17/10/23 in respect of the same, my lord, cooperative society, my lord. Assam State Cooperative Union. ASU.
What remains, sir?
Nothing remains, my lord.
Well, that is their contention. Our contention is that you have a status of.
If your lordship comes to para 22, my lord, this honorable court has held.
Para?
22, my lord.
22.
22, my lord.
Yes.
On consideration of the materials on record, it transpired that the ASU is a cooperative society registered under the Assam Cooperative Societies Act 1949, now Assam Cooperative Societies Act 2007. There is no deep and pervasive control over the ASU by the state government. Therefore, we are of the view that ASU cannot be said to be an authority or instrumentality of the state under Article 12 of the Constitution of India. Writ petition may be maintainable if it is established that the government has deep and pervasive control of the cooperative society. However, in such a case also, the claim would be against the cooperative society, which may fall within the meaning of authority, instrumentality of the state under Article 12 of the Constitution of India. In any event, the writ petitions are not maintainable against the state of Assam, which has no liability towards the ASU or its employee. Resultantly, no claim for payment of salary against the state government would be maintainable. Then if your lordship comes to, my lord, para 26, the judgment of the Supreme Court, my lord, in Barak Upatrika DU Karmachari Sanstha, my lord, has been
my lord, consider it has been expected, and the second paragraph, my lord, would be relevant. Para 26, my lord. The extract of the Supreme Court judgments, my lord, second para. If the salaries are not paid, the remedy of the employees of Kamul, this was also a cooperative society, my lord, is to proceed against Kamul in accordance with law by approaching the forum under the appropriate labor legislation or the Cooperative Societies Act. But the trade union representing the employees of a cooperative society cannot, by filing a writ petition, require the government to bear and pay the salaries of the employees of the cooperative society, howsoever pervasive the control of the state government over such society. Nor is any right created to demand the continuance of financial assistance to a cooperative society on the ground that such assistance has been extended by the government for several years. The respondent has not been able to show any right in the employees of Kamul against the state government or any obligation on the part of the state government with reference to the salaries, emoluments of employees of Kamul, either under any state or contract or otherwise. Now, para 27, my lord. In the present case also, the appellants have failed to show any right against the state government or any obligation on the part of the state government with reference to the salaries, emoluments of the employees of AKSU, either under any statute or contract or otherwise. Mayor's sporadic financial assistance by way of granting aid for several years neither make state respondent responsible to bear salaries of employees of AKSU nor create any legal right to demand continuance of such granting aid. Therefore, no writ is maintainable against the state government of Assam. Consequently, no direction can be issued for payment of salary to the appellants as well as for providing granting aid to AKSU in respect of the same cooperative society, AKSU.
Well, so far the act, I have given a copy of the act. This act came into 2010. Now, under this act, all these institutes have been taken over the function of the, this is the. This
judgment is binding on us.
Well, binding means if your lordship agrees, then it's binding. If your lordship dissents, then your lordship, then it's not. It's a coordinate bench. I need not tell this honorable court which is binding and which is not binding, my lord. Now, if your lordship looks at paragraph number 16,
yes,
your lordship has seen that it talks about the Assam Rajiv Gandhi University of Cooperative Management. So this Assam Rajiv Gandhi Cooperative Institute of Management came into existence in 2010. And all these institutes, this is particular, it has been taken over by the Assam Rajiv Gandhi Management, that University Act. So, my lord, these persons who are working from 2012, now we are in 2024, still working. We need to find out a way how to get their salary paid. And my contention is that this
Supreme Court has clearly guided you.
no, madam, then
Go and if any claim of salary, you can very well approach the Labor Legislation of Cooperative Societies Act. By approaching a forum under the appropriate labor legislation of the Cooperative Societies Act.
then, my lord, may I propose one thing, my lord? Since these petitioners are in the corridors of this court from 2013, so this limitation period from 2013 to 24, we have been pursuing a remedy here. Today, we are told that.
That is the question.
So,
Move an application under section.
so
14 of the
this
limitation.
period may not be considered as
Sir,
inordinate.
that still you have not even approached the organization, and it is in fact, it's a running cause.
Yes, well, that's why your lordship may kindly observe to that extent. Your lordship may kindly observe that since we are pursuing a legal remedy out here, so that will not be case a hurdle in
Sir, if there is any delay, you can very well move under section 14 and application.
that may kindly, because normally,
That is within the domain of the court to consider it and not to consider.
well, if you approach, well, that should not be a hurdle for the so far the limitation is concerned. Well.
Limitation, what's the limitation?
Because inordinate delay, they may say that we have come here, your dues have accrued from
Then
2012.
we have approached the court and now the court has come with the view that this writ is not maintainable, then only we have approached this court. That is there. And it's ultimately, it's a running cause.
that my humble submission is that incorporation of that line may assist these people, who has lost their one of the petitioner has died pursuing this legal remedy.
It is only in case of unexplained delay that the petition can be
But even then.
there is
your
an
lordship-
explanation, you have been pursuing a remedy, so.
My lord, that observation will not cause any prejudice to them also, my lord. That will only be a bump to the petitioners who have been before this court from 2013, and today we are in 2024.
The appellants who are working with the Assam State Cooperative Union, ASCU, has approached the learned single judge by way of filing the writ petition, essentially with the prayer to direct the respondent state to make the payment of their due salary and the other amendments as revised from time to time. The learned single judge has dismissed the writ petition filed on behalf of the appellants while observing that since the appellants are the employees of state, Assam State, ASCU, and not the employees of the state, no mandamus can be issued to the state for paying their monthly salary and other emoluments as revised from time to time. Being agreed with the same, being agreed with the impugned order passed by the learned single judge, the appellants have preferred this writ appeal. Learned counsel for the respondent has submitted that the question has submitted that the issue involved, the question involved in this petition is no more res integra. And res integra as the coordinate bench of this court in writ appeal number 5/2022, Sri Amarjit Burman and others versus State of Assam and others and other connected writ appeals has already taken a view that the employees working with the ASCU are not the employees of the state, and therefore has already taken a view that the ASCU cannot be said to be an authority or instrumentality of the state under Article 12 of the Constitution of India. Hence, writ petition against the hence the writ petition filed by the appellants against the state seeking the relief of payment of salary is not maintainable. Full stop. Having gone through the judgment passed by the learned single judge by a coordinate bench on dated 17/10/2023 in writ appeal number 5/2022, Shri Amarjit Burman and others versus State of Assam and others, and other connected writ petition. We are in full agreement of the same. Hence, hence we don't find any illegality in the impugned judgment passed by the learned single judge, whereby the writ petitions filed by the appellants have been dismissed as not maintainable. Hence, no case for interference is made out. The writ appeals, the writ appeal is dismissed. However, the appellants are free to approach the forum under the appropriate labor legislation or the Cooperative Societies Act for redressal of their grievances. It is also observed that if there is any delay on the part of the appellants in approaching the appropriate forum, the question regarding the condonation of delay would be taken into consideration sympathetically.
We are, we are deeply obliged.
Item 14 to 18.
Yeah, please, your lord. My lordship. This is regarding, my lordship, promotion to the post of headmaster of MEL school, my lord.
On a dog basis.
No, my lordship. We are regular teacher, my lordship. Since 2014, no promotion has been made, my lordship. In the year 2021, a gradation list has been prepared by following the due procedure, my lordship. And thereafter, a selection list has been prepared. And this was sent to the government, my lordship. And
You're from the state. Mr. Jumdar, you're from the state. Still, you have not specified the reservation.
That reservation was sent to the WPT and BC department, which had come back. That came back sometime in December, madam.
In
We're calculating-
2022.
2023 December, the WPT and BC department has returned it back to us.
Why?
And there was some clarification. I exactly do not remember now, but there was another matter in which.
How long will these promotions will be withheld? Seen only because the specifying the vacancies have not been specified for the purpose of reserve category.
The gradation list, this act itself underwent an
So it's
amendment.
almost 2 years.
The act
This
is,
court has, the judgment is passed and still you are waiting for that. That's very sorry state of affairs.
we will have it tomorrow, madam. I'll-
Promotion is withheld only for the reason that the government has failed to specify the vacancies for the reserve categories. It's too much.
That has to come from the appropriate
Whatever
department.
it may be, sir, who are the authorities ultimately, all are the instrumentality of the states.
I appear for the education department, my lord. I do not have, we do
I
not have a control
Here
over
I
that
don't
department.
understand this business. That is the education department, and this different department is different, and this department is ultimately you are representing the state. Who is this WTPC? What is this?
my lordship, welfare, plains and tribes.
WPT and BC department, कौन सा है ये department? Which is that department?
Where is Mr. Dhar? He is the standing counsel. R Dhar.
It's in court 10, my lord. He's appearing in court 10, my lord. I'll send for him. I'll send for him.
Pass over for the timing. And complete your instructions, or otherwise the person who is responsible, the secretary education department should remain present on the next date of hearing before this. You without the promotions for last 2 years, I don't know, writ petition is of the year 2021 or 22.
The difficulty
22,
is,
my lord.
the difficulty is, these very petitioners, they appear, they prefer different petitions at different points of time, get a stay order, my lord. Process has stayed and we cannot proceed, my lord. We have got that on record also, my lord.
Specify the vacancies for reservation on account of stay.
My lord, no, but
No,
we are not, it is not that we are not declaring the vacancies, my lord. The process of promotions are kept in abeyance many a times because the same petition, I have
That is
put it on
altogether-
record, my lord. They have.
That is
preferred-
altogether, that is altogether a different matter, whether you have specified the vacancies for the reserve category or not.
That I'll
And
have,
from how much
I'll have
time
it.
you have not specified?
I'll mention.
पार्टी नहीं बनाया council bata. Education department prays for and granted a week's time to clarify that why the education department has failed to specify the vacancies for the reserved category for the post of headmaster / administratress of provincialized ME/MEM/MVN senior basic schools of the district of Hailakandi. List on 24th of
Highly of like, unless.
Item 19.
Yes. Yes, Mr.
When I filed my affidavit, the, this is basically all the drains that leading to Brahmaputra. Basically, there is a Bhorulu river which pollutes all the pollutants comes to Bhorulu river. That we have started a project, my lord. The STP is coming up in two places, and another special agency has been created by the government to assign the first phase of, and money has also been in sanction of 1,460 crores.
Your affidavit?
Affidavit filed by the Additional Secretary Department Housing and Urban Affairs. It starts from page number 20, TL page number 27.
Loni Gorapatra Gore?
No, my lord, Loni Barpot had filed affidavit.
Alcazar Ali.
Alcazar Ali.
It was filed on
Yes.
On 7th
Alazar Ali.
March.
yes, Alakzi.
Alcazar Ali is the Additional Secretary of District.
With the required fee, serious treatment has been taken over by the technical proposal. With the Education Committee. 2030.
Student
They
is the
propose-
project will be completed.
Lord, Lord, we are in 2024 and project will, it's a big project, Milord, it will be completed in 2000. Milord, what about in between, Milord, 6-7 years, Milord, 6 years? Because it's an alarming,
They've done nothing.
it's an alarming situation, Milord. Lordship has perhaps seen also.
They've
The
done nothing.
Milord, I have filed one report, Milord, wherein there was a committee formed by the government itself. And that committee in the year 2019, Milord, suggested action plans. They just set over that. When I brought this before this honorable court, then they woke up. And now the situation is that they are saying two places they are sitting, Milord, constructing STP. One is Sorusala bill and another is Borsala bill. Milord, what about the other places? Now they are saying that they'll sewage treatment plan under the
by spending 1,000 crore rupees there, creating, and that will,
You file a counter to it. Okay, you file a counter to it. That only these two treatment plants they are providing, but in fact it is these number of severe treatment plants are required.
my lord will kindly come for a moment to the report, my lord, action plan. My lord, the problem is that,
That action plan, this
yes,
statement report by the standing council of the.
yes, my lord.
Yes.
In that para 8.3, my lord,
Page.
it will be, my lord,
It is not part of the record because what my friend has bought.
my lord, down below page 27, page number is given. 8.3. This is with regard to biomedical waste generation and gaps in treatment, orally reverse stress.
Yes.
I'll just show one data, my lord. Guwahati Municipal College Hospital, Bhangar, Guwahati, red. BMW is 468. Others all are orange. But the sewage treatment plan, they are erecting in Porukhoja and Borsola Bill, not nearby to Guwahati Medical College. That is one aspect.
They are coming up with HT. We can ask it why it happened. Interim measures there.
Example attached to. Then my lord can come serial number 13 action plan by the committee. Committee itself has said what are to be done.
That now they have started doing something. Now they, Mr. Das, yes, you're right. It's a matter of concern that since 2019, they are sitting over it. Now, if they have come with some plan, then let them start with it.
One small initiative like stainers, using stainers. If the major drains from which the entire waste water of the city comes to the Borolu River, if a stainer can be used there or above the Borolu,
Why don't you give some suggestions which can be looked in as?
it's already there in the managed, my lord. The committee's recommendations is already there. They are only required to implement, my lord. My lord, lordship will see in page 34, the committee has already said to trap the discharge using stainers before falling into river. Look, I am not a technical person, but the technical persons who are involved in this entire process, they have given the recommendation. They are simply do. STP, I understand it will take some time. But so far as other limited measures, why you are not saying all those things?
Mr. Bora, what are the interim measures? 6 years waiting for this to,
It's a big project, it will come up, my lord.
so let it come up, but what are the interim measures, interim steps? The city cannot wait for 6 years till pollution control measure is brought into effect. You have already recommendations by the expert committees.
In the meantime,
What is your stand on that?
let me get up, let me get the instruction. What is the in the meantime, what they are doing?
And council for the respondent has submitted that. In the affidavit filed on behalf of the Secretary,
Additional Secretary.
Additional Secretary, Department of Housing and Urban Affairs, Dispur Guwahati, the measures taken by the the proposed measures for dealing with the problem of pollution in the Baralu River at Baralu Mukh, Guwahati has been detailed out. Full stop. As per the said measures, the three numbers of STP, the serious treatment plants are proposed to be constructed at different locations. In the affidavit, it is mentioned that the project phase one and the phase one and phase two of the project are scheduled to be completed by year 2030. Stop. Learned counsel, the learned amicus curiae, standing counsel of the High Court, Mr. H.K. Das, has submitted that as a matter of fact, a action plan for Balu River has already been prepared way back in the year 2019. And the state government has now come with a project to deal with the problem of pollution in the Balu River in the year 2024 only. And the council has submitted that though in the action plan, certain interim measures have been suggested till the whole project is completed, but those interim measures have not been taken by the respondent state. Full stop. Having heard the learned counsel of the parties, we are of the we direct the respondent counsel for the respondent to furnish the details regarding the interim measures to be taken by the respondents to deal with the pollution in the Balu River till the completion of the project, which is scheduled to be completed in the year 2030. Just after 3 weeks, submit the what interim measures you have proposed to.
And one of the affidavit, man, I proposed that aerosters will be placed before the river, Bhorlu. In paragraph number 7 of the affidavit filed.
Whatever maybe you first. Yes.
Item 20. May please your lordship. My lord, in this case, my lord, the government side has taken adjournment on number of occasions to file affidavit. The government has not filed any affidavit. My lord, we have filed affidavit only. We have not filed any affidavit, received any copy of affidavit from the government side. Only circle officer filed an affidavit. Government has not filed
Who has conducted the exercise of this recasting the panchayat and area of the recasting the area of the panchayat and
District administration, my lord, on the behalf of district administration, circle officer again file an detail affidavit.
and now the state government is required to file any response.
I think the
Yes,
state government,
state is to file affidavit.
circle
They have
officer is a
taken-
part of the state.
They have taken time on several occasions, madam.
This will do, my lord. Circle officer on behalf of the DC district.
The person who has conducted all the exercise, he has to justify.
Exactly, my lord, circle officer is the
If
only.
the is filed, you want to any file, the state is not required to any file, and if they are not willing to do so, what we can do?
Circle officer, my lord, and only, my lord, he has been not served with a copy. I'll serve him today, my lord.
That you are for the state.
No, I am for the Arbitration minister, that's for 7.
Corner number 7. Sir, if they are not willing to file any reply on behalf of the state and said that
They are not
reply
filing
of
that. Let matter come after vacation, my lord. Matter will dispose of.
then in concept of the Mr. So and so appearing on behalf of the circle officer has submitted that
12456, my lord.
12456 has submitted that reply to the petition, counter on behalf of the state. And the other respondent, and the other respondents have already been filed. The net counsel appearing for the respondent number 7.
We have not received the copy. We'll serve him by today, madam.
Take some time to file counter to the petition. Respondent number 8 and 9 are. But these are the performer respondents, I think.
Mal.
Chief electoral officer and electoral registration officer, you are appearing for them. So who is the electoral registration officer is the one in the same scene. Chief electoral officer and electoral registration officer. It's okay. The respondent, then consider the respondent is appearing, so is appearing on behalf of the respondent number 8 and 9. This petition for admission after 4 weeks. Check.
Leave lovely. Item 21.
Madam, my friend is supposed to submit a
The original prayer of the petitioner is for regulation of his service. The learned single judge said that the regulation cannot be given and the minimum pay benefit has been directed to be provided. Now the ground has been taken that in another writ appeal, there is an order for consideration, and in view of that, he should also be given the same benefit. That and kindly similar the prayer. The under the above
Prayer of the
prayer in the writ appeal, page 17. Page 17, my lord. Under the above circumstances, it is therefore prayed that this honorable division bench may be pleased to admit the writ appeal, call for the records, issue a notice calling up the respondents to show cause as to why appellant should not be granted the relief as prayed for in under item number G of the memo of writ appeal. That is for regulation. The similar order that
item G.
Item G that page 16 lordship will find. Page 16, 16. Relief software. Setting.
The item G is
page 16, 16. No, page, item G in the writ appeal itself. The item G is the relief software in the appeal. They have prayed for setting aside and quashing of the impugned order dated 2823 passed by the learned single judge in WPC number 5508 of 22. So for rejecting the prayer of the appellant for regulation of his service and consequential benefits. And next is directing, commanding the respondent authorities to regularize the service of the appellant from the year 2005 as the services of other similarly situated master or workers engaged prior to 1493 have been regularized by order dated 5/10/2005 and to pay all consequential benefits. So while praying for this, the petitioner has placed reliance on a division bench order. That division bench order, lordship will find at page 29.
29.
Page 29. It starts at page 28, but the order starts at page 29. The operative portion is next page, page 20. Next page, my lord. Para 8. Accordingly, we direct that the case of the appellant will be considered for regulation by the authorities, provided he is eligible for regulation under the scheme, irrespective of the delay in approaching this court. If the scheme still continues and the appellant is still eligible to be considered, as to whether the appellant is eligible for regulation or not, is an exercise to be undertaken by the authorities by taking into consideration all the relevant records, documents without referring to the issue of delay. Well, pursuant to this, the order which I have placed before Lordship today, that has been passed.
That also we have challenged, my lord, in another writ petition.
That is pending.
It is pending in the High Court.
It is pending. Notice has been.
My lord, matter is so a small issue. My lord, it is being admitted by the executive engineer that while sending the name, two names were wrong. It is their mistake. They have admitted. Now, in the meantime, my lord, I am a Group D worker. I said my name has already forwarded. But later on, when everybody's name was regular service was regularized, it appears that my name was dropped. It is then ultimately their mistake. They have admitted in their letter to the authority.
What the learned single judge has held?
Well,
It is not possible to regularization, but you will get the financial benefit.
So what's wrong in that?
It pays 26.
Wrong means, when it is admitted that if it is regular, I will get the pensionary benefit.
But regularization, how you are entitled for regularization?
Because it is under scheme 2005, there is the government decision that all master roll worker will be regularized.
Having heard the concept of the parties, we are of the view that matter requires consideration, admit no need to issue notices as parties are already represented through concepts.
Lordship.
This for the hearing in due course.
Lordship.
Item 22.
May it please, Your Lordship. Lordship, matter pertains to recruitment in Moligar Refinery Limited for lower grade of employees, Lordship. Or they have the gradation of 4, 5, 6 lower grade. It goes on not like the government gradation, Lordship. So they have a rule, certain rule, Lordship, which they had placed
Now,
before, Lordship.
now they changed the rules.
They have changed the rule, Lordship, but now still, Lordship, they want 30% reservation for the local, Lordship, employment exchange candidates, Lordship. That is Golaghat employment.
Earlier it was 100%.
Lordship,
Lordship.
may I submit, Lordship? Lordship, petitioner has challenged our rules. And we have amended the rules accordingly, but we have a obligation towards the district where the refinery has been set up. Because we have a no development zone from Bokaghat to Kaziranga, Lordship, where no industries can come up. So the only liberty consideration which we are seeking is a 30% reservation for the district of Golaghat for the local employment. That was understood when the Assam Accord was signed. And 70% we want to make it open to all India basis. And we have already placed that resolution and the amendment before this vote on the last date, Lordship. If Lordship would like to have a copy of it. Rules, Lordship, amendment of clause 7.1.1 and clause 7.1.2, Lordship. Source and procedure of recruitment. Lordship may kindly come to the amended part, Lordship, 7.0, source and procedure of recruitment. Recruitment will be done through employment exchanges in the state of Assam. Vacancies shall be notified in the prescribed requisition form to the Directorate of Employment and Craftsman Training and also to the Golaghat Employment Exchange. 30% of vacancies shall be reserved for candidates from Golaghat district to the Golaghat Employment Exchange. In case adequate candidates are not available from the Golaghat Employment Exchange and on receipt of a non-availability certificate, the shortfall percentage of vacancies shall be filled in by candidates from other parts of Assam, Lordship. So my friend's grievance is that it should be made open. The whole process should be 100% should be made open to the these posts should be advertised. My humble submission is if Lordship would grant us this 30% only for the state of Assam and for the district of Golaghat, Lordship. And we have accordingly.
Earlier, what was the provision? Now this is the amended.
This is the amended. Earlier it was 100% for the district of Golaghat, Lordship. And that was a promise made by the refinery because of the Assam Accord, Lordship.
the basis of any promise or the accord,
Yes, Lordship.
then you can make a provision for reservation of 30% seats
Only for grade 4 and 3, Lordship.
recognized by the law.
It is not, but this court has ample
not-
power, Lordship, to grant us that.
If it is not allowed under the law, how can we grant you the?
I leave it to Lordship. Lordship, we have amended it. We have placed it before this court. If Lordship,
But you have to justify it.
our justification is Lordship because there's a no development zone, no industries. It is only for local employment.
Even though your justification may be correct, but it is permissible under the law or not? That is the question.
Lordship, some PSUs,
Permissible, then certainly you can do it, even you can do it up to 50% or 100% or 10%, 20%, 30%.
this
But
is
what is
our,
the basis of this 30%? Is
This
it
is-
permissible under the law, then we'll allow you. Otherwise, even though
Lordship,
whatever any good intentions behind it, but if it is not supported
it
by
is
law,
a
we can't
special consideration which we are praying for, Lordship.
do it. Have you placed it on record?
We have placed it, we have not filed an affidavit, but we have
File
already,
an affidavit.
we file an affidavit, Lordship. We'll do that.
Show your justification. Okay. Let it transfer to the respondent, Maligan. Refinery has submitted that the provision of 100% reservation and recruitment in the recruitment from the candidates for candidates from Golaghat district has now been amended and it is provided that only 30% of the vacancies shall be reserved for the candidates from Golaghat district. Stop. When it transfer for the respondent is granted time to file affidavit, counter affidavit to justify the action of the respondent Numaligarh Refinery Limited for reserving 30% of the vacancies for candidates from the Golaghat district. Just after 3 weeks,
Lordship, 2 weeks.
2 weeks.
Yes, sir. Much obliged. Lordship.
Item 23.
May it please your Lordship. Your Lordship, this PIL, the main issue of this PIL is use of
That I don't go here, so down pin is a ban like point of view.
May it please your Lordship. May I, your Lordship?
The issue regarding hazardous pesticide in the state
Yes.
of Assam.
Yes, your Lordship. And this matter was closely monitoring by this Honorable High Court, your Lordship. On the last occasion, your Lordship, an affidavit was filed by the respondent number 3, that is Commissioner and Secretary, your Lordship. And the file on 27/9/2023, your Lordship. I would like to highlight one annexer, your Lordship, that is page number 2225, your Lordship.
215.
225, 225,
25.
annexer 5.
Yes.
Yes. In this annexer, they have mentioned detail of unsafe samples as per analysis report of State Public Health Laboratory, Bamuni Moidam, your Lordship, where they have stated some sample has been collected on 26/03/2023 to 3/4/2023. Here they have mentioned some chemical, your lordship. If your lordship will see the serial number 4, your
Yes.
lordship, yes, methane phos, which also cause phos dream. This is already a banned pesticide which has been found in the vegetables of Assam, your lordship. As well as if your lordship will see serial number as mentioned 33, your lordship. And the chemical 33, your lordship.
33.
Yes, it was not serially actually given. After 118, it was stated at serial number 33, your lordship.
118 and serial. It's not there. This 4 is coriander leaf,
Yes, after that, your lordship.
carrot,
Yes, your lordship.
ridge gourd,
Yes,
green chili,
yes,
cucumber,
yes,
cauliflower,
yes,
bitter ground,
yes. Again, cucumber, capsicum, coriander,
coriander leaf, cabbage.
pointed gourd. Yes, your lordship.
Pointed
This
gourd.
one.
Yes.
Yes,
pointed?
lordship.
Yes.
Yes. And they have mentioned one name on the pesticide that is monoprophos. And this is already a banned pesticide which was banned in the year of 2005.
And
Yes. And which I have already mentioned, methylphos. This is a banned pesticide which is banned in the year of 2021, your lordship.
fine.
April 2021, your lordship. So now this pesticide is easily available in the vegetables.
Where they are referring the names of the district?
They have referring the information drawing area, your lordship. Yes, Morigaon. And another one is West Bengal, your lordship. They have mentioned the name of the farmer's name, one Runu Deka, and another one is missing, your lordship.
So if it is this, whatever the drug, it's coming from West Bengal, then whatever the pesticide,
Yes, your lordship.
it is generated or whatever the vegetable or the item
Yes, your lordship.
is imported from the West Bengal,
Yes.
almost all are unsafe.
Yes, your lordship. All are unsafe, but these two are
So I think so they have suggested some measures to.
have this practice, your lordship.
No, you are not satisfied with those measures which they have suggested.
No, your lordship.
Why?
Because the equipments, we are very lack of equipment. Yeah, in this petition, they have also mentioned only one laboratory is here in Assam.
Why
We
you
have
are counter to this that or suggestive measures? We'll consider it and then we'll ask them to file their response in respect of that.
Yes, your lordship. If your lordship allowed, then I would like to place one their report. Yes, in page number 231, your lordship.
31.
Yes, they have one proposal has been submitted by the Commissioner of Food Safety Assam. In page number 232. Started from page number 231.
Yes.
Yes. They have given a proposal, your lordship, to the Principal Secretary, Government of Assam, Health and Family Welfare Department, Dispur Guwahati 6. So the present status of this proposal.
What is the proposal?
Yes, your lordship. In page number 232, your lordship.
Yes.
Thus they have proposed for some instrument, your lordship, which are required for the testing of this chemical pesticide in the foods as well as soil as well as water, your lordship. They have stated that the said instrument are proposed to be procured through GEM, Government E-Marketplace, at the commissionerate, and hence the total figure proposed is likely to vary. They have submitted a figure that amounts to 7 crores 40 lakhs 30,000, your lordship. So they are seeking some instruments so that they can curb this practice of using chemical pesticide in the agricultural field of Assam, your lordship.
So whether they have provided any fund, the state government has provided any fund or not?
I'm not aware about this, your lordship.
you can do one thing. If you have any objection regarding whatever the action taken plan they have, but to find a short counter to it, then we'll consider it that these are the shortcomings in the report or whatever it may be, and then only we'll call them to file their response. Yes?
Yes, Lord.
Yes. This payer petition, the petitioner has raised concern about the use of pesticides, hazardous pesticides in the state of Assam. And also sought ban of advertising and practice of marketing the promotional chemical pesticides. In response to the PIL petition, the Union of India, it is by the Union of India or State of Assam?
Union of India, Your Lordship.
This response,
This is from State of Assam, Your Lordship.
the State of Assam has filed its response, wherein certain measures have been indicated, which the state has taken for restricting the use of hazardous pesticide in the state of Assam. Stop, the concept of the petitioner raise some time to file response to the counter filed by the state of Assam. Time period for is granted just after 3 weeks. Thank you.
Obliged, Lordship.
Supplementary list for orders item 63.
Wait, Your Lordship.
There is a delay.
17 days, you know.
Action of this of IN
State
number
respondents are there. All forest council would represent everyone. You know.
Where is it?
I had a word in the morning, they did not have an objection, they said, but doesn't,
Objection, let them call them.
may after some time.
Yes. Before is the same, I think.
No, 64 अलग है.
Maybe delay here.
64 में delay नहीं है.
Item 64.
May I please, Your Lordship, there is a delay, my lord.
Delay.
There is a delay, my lord. My friend is appearing for the private respondent, my lord.
Excavator, my lord.
Excavator, he has appeared.
Who is appearing for the state?
The stage is for the secondary education, my lord.
58 days delay.
My lord, my lord,
Will issue the notice.
my lord.
Issue notice of the IN number so and so. Mr. So and so is appearing on behalf of the private respondent number 4.
Four.
Let notice be issued to the respondent number 1, 2, and 3, returnable so and so.
They have standing counsel.
No, my lord.
Standing counsel.
Secondary education.
Mr. So and so, Mr. So and so put in appearance on behalf of the respondent number 1, 2, 3. Mr. So and so put in appearance on behalf of the respondent number 4. Do you have any objection?
Lordship, my lord, I file objection, my
What objection?
Lordship, my lord, here, my lord, fact is that, my lord, the impugn order in the petition, my lord, that was passed in the year, my lord, 2022, my lord.
That
In
was
the
only 58 days delay.
Lordship, my lord, that's why I'm submitting, my lord. In the writ proceeding itself, my lord, there was, in the entire writ petition, my lord, there was no stay, my lord. In spite of that, my lord, he has not handed over the search to the respondent number 4, my lord. And thereafter, my lord, writ petition has been dismissed, my lord. And thereafter also, my lord, he has not handed over the search, my lord. And ultimately, my lord,
Charge of what?
Charge of headmaster, my lord. Headmaster, my lord. Thereafter, my lord, so-called notice was issued, my lord. In spite of that also, my lord, he has not, my lord, handed over the search, my lord. And now, my lord, this petition has been filed, my lord. And so far, my lord,
Minister, how if he has not handed over the charge, how? That is,
now-
the department will take care of that.
Lordship, and my lord, moreover, my lord, some statement has been, my lord, here, my lord, incorporated, my lord, in paragraph number 3, my lord.
We hear the matter on merits.
No, my lord, cause of delay, my lord.
Yes.
So on that, my lord, I have to file objection, my lord.
What is the cause of delay?
In paragraph number 3 of IA, my lord.
Yes.
He stated that, my lord, he was suffering from some medical illness, my lord, but no specific medical illnesses, my lord, stated, my lord. And moreover, my lord, another statement he made, my lord, he took some time for official formalities to complete for handling over the charge, my lord. But till that, my lord, no charge had been handed over, my lord. On that count, my lord, I have to file objection, my lord. Kindly, my lord, some time may be granted, my lord.
Impugned judgment is dated January 2024.
29/1/2024.
58 days. I'll file my lord short affidavit.
If the writ, appeal is decided on merits, maybe in your favor.
And that's
Good for you.
and that's true, my lord. But even then, my lord.
Mr. Borua, I think you are unnecessarily delaying your client's own interest. Because the more you delay
If you
this,
have
you
good
know
case
that-
on merits, what's the hesitation in
No,
condoning the delay?
That is true, my lord. But in this petition also, my lord, I want to file objection, my lord. That's why. After
Is
vacation.
there any, your instructions are complete?
Lordship, my lord, yesterday evening only, my lord, I get
Instructions.
some instruction, my lord, yet to be come, my lord, but our telephone, my lord,
Instructions,
our telephone, my lord, our telephone, my lord, I talked with the
Material
client, my
instruction
lord.
is complete or not?
Some instruction as well as my lord, document, my lord. yet to
What
come.
my lord is asking, material instructions
Material,
are complete or not?
That, that, my lord.
There is some due, come. The due note. You can know the delay, 58 days, nothing. It's only January.
After your lordship, my lord.
So, yes, ma'am, do you have any objection? This IA comes upon consideration of the prayer of the petitioner for condoning the 58 days delay in filing the connected appeal, connected rate appeal. The net counsel appearing for the respondent number 1 and 3 has no objection. If the delay is condoned, however, the net counsel for the respondent number 4 has submitted that the applicant has failed to explain the delay satisfactorily. Having heard the learned counsel for the parties and after going through the contents of the IA, we are of the view that the delay of 50 days in filing the present appeal is liable to be condoned, hence IA is allowed, delay is condoned, registry is directed to register the connected appeal and list it before this court for admission after 2 weeks.
Pass over matter 63.
The delay of 17 days, the lordship, we have no objection.
You have no objection. This IA is filed on behalf of the appellant with the applicant with the prayer to condone the delay of 17 days in filing the connected appeal. The counsel appearing for the respondent has no objection if the delay is condoned. In view of the above, having heard the learned counsel for the parties and after going through the contents of the IA, we deem it appropriate to condone the 17 days delay in filing the connected appeal. Hence, IA is allowed. The delay of 17 days is condoned. Registry is directed to register the connected appeal and to list it before this court after 2 weeks. Listed for admission after 2 weeks. Yes, IA disposed.
Daily list for hearing item 25.
Me please your losses.
My lord, before my senior starts, my lord, I'm seeking a little accommodation today, my lord. The K. Gogoi, the assisting counsel to the learned AG is not available today, my lord. He has some personal difficulty actually.
No, requested him. My lord, in advance, before lunch, my lord, I have spoke to the assisting counsel. Before lunch, he was no difficulty. No, he was there, my lord. He was in the court, my lord. Then my lord, now he is not feeling good. Now he is not feeling good, my lord. That's why he has been left the court, my lord. In the lunch, what happened? I don't know.
The matter is unnecessarily, my lord, delayed. It is an appeal of 2020. And my lord, in the event your
So,
lordship,
Chaudhary, we have to adjourn it or not? Do you have any objection?
I have objection if your lordship, my lord, goes to the order sheet. One day, my lord, they say that Mr. Gogo will appear. Then another day they say that my lord, the AG will appear.
No, my lord.
And even if my lord, eventually, if your lordship allows our petition, my lord, my clients may no longer be eligible to apply for the post of assistant professor. That is the position, my lord. And issue is actually very limited, whether my lord, UGC regulations are to be mandatorily followed by the state or not. That is the issue.
Lanet Singhal just said this insofar as regarding the colleges run by the state government, this is not mandatory.
Yes,
So
my
that
lord.
follow the.
That is what I am challenging, my lord. That is
This
what
is
I am
not the
challenging.
point.
And your lordship knows, my lord, there is a decision of Honorable Justice Shyam also that it is mandatory. And there are Supreme Court decisions, my lord.
So and so appearing on the respondent's place, some has submitted that since the senior counsel is not feeling well, they met a short accommodation be granted. Full stop. Learned counsel appearing for the petitioner as opposed the request of adjournment. Appellants as opposed the request for the adjournment. In the interest of justice, one more opportunity is granted to the counsel for the respondents. This matter 30th of.
My lord, your lordship may kindly observe no further adjournment will be given.
Even though if we observe and some request is made, then
But then even then they may not like to make the
on
request.
that day, maybe if you are in some work, you may be busy in that. Yes.
All right.
Item 26 to 58.
I have seen one case, my lord, in respect of item number 38. There is an order, my lord.
What is the order?
Order, my lord, your lordship. এটা আছে না? এটা third paragraph, my lord. By order dated 25/7/2023, my lord. As such, registry to verify the records and carry out regrouping of the cases after taking necessary input from the learned departmental counsel. The learned counsel for the appellate petition would also be at liberty to furnish necessary input to register pertaining to the respective cases, including other pending matter connected to series which is not been listed today. Needless to say, after analyzing input received from the learned counsel for the parties on an examination on record, if it is transparent that the matter listed today in this series is not required to be dealt with any specially considered division bench for a reason to be recorded in writing, those may be segregated and listed before the appropriate bench. So many different issues there, judgment by some
different category of teachers.
We are in OBB, for pensionary benefit for same OBB. Some of the cases.
What do you want?
My OBB case may be segregated separately.
Here at the time of hearing, we'll segregate those cases and here it different separately. So. What about the other matters?
All are there, man.
Yes.
And what is 26 you know?
There are
Regarding excess.
25 number of cases, more than 25 cases are there. So if you are appearing in 26, he is appearing 2-3 matters. What about the others?
I'm appearing for OBB teachers, 41, 42, 43, 44, and supply 65.
You are ready to argue the matter?
No, my.
No, we are
Today.
taking time to me.
Delegate.
Lordship, item number 57, Lordship, this is separate, it is 6 schedule area, Lordship, and
It's a
6 schedule area of NC Hills, Lordship. Their service condition was something different from the others, Lordship.
We'll take one by one, no problem at all. Let them listed along with. We'll take by one.
Otherwise also, Lordship, they were retired during the period 2016 to 20, Lordship. One is already expired. So it is segregated, Lordship.
These bunch of writ appeals involves the question regarding grant of benefit of old pension scheme vis-a-vis the new pension scheme. And also the claim of school teachers under the OBB scheme to the various category of employees. Stop. The learned single judges decided all the claims by a common judgment. In such circumstances, we also feel appropriate to decide all these writ appeals together. However, at the time of hearing, the regrouping of the cases of the similar nature will be done and will be considered separately from the other group of writ appeals. List on. At the request of the learned counsel for the party. These writ petitions on writ appeals on 6th of June 2024. On that day, be prepared for that.
March.
Item 59.
Lord, I am not feeling well. This will be taken after vacation. I have taken the consent of my learner friend.
You are looking well.
I am not feeling well.
You are looking well, not feeling well, but you are looking well.
No.
No. Yes.
Since he is not.
Whether is not feeling well, though looking well.
There is something
Since he's
wrong
not keeping well,
internal.
my lord, so he's not keeping well, I don't have any objection.
Just after
Date. At the request of learned counsel for the respondent, list these matters on front. After 4 weeks, cut them.
Oblige.
Item 60 and 61.
May I please, your lordship? Lordship, so far as item 61 is concerned, my lord, what has happened in item 60, this is a intra-court appeal, my lord, filed by the writ petitioner, who is the writ appellant out here. My lord, being aggrieved that his writ petition was dismissed. But in item 61, this writ appeal has been filed against that judgment of dismissal of the writ petition. The writ appellants claim that they are necessary parties and they are affected by the judgment. So this writ appeal has been filed, item 61, seeking a leave of this honorable court. this honorable court was pleased to grant leave to file this appeal. Accordingly, my lord, this week appeal are listed today. Now, my lord, I am praying, my lord, for little accommodation from this honorable court to file an affidavit, counter affidavit, so far as item 61 is concerned. Because on facts, my lord, we
Item
need to
61.
traverse.
You
For
are
me,
61.
so for me, there is a, but together your lordship here wants to hear
Yes.
both the case together. That is why it was fixed together.
That, against the same judgment.
Yeah, against the
Same
same
judgment.
judge.
But under that circumstances,
He
I
wants
pray,
some
my lord,
time.
I am
I said you have to tell the court. For me,
But
I'm-
first of all, he is required to take your consent.
no, for me, absolutely no problem.
Then, if you don't have any problem with,
I don't have any problem.
I am seeking an accommodation of at least 3 weeks, my lord.
3 weeks.
3 weeks, my lord. We have to
That
gather
is-
materials,
yes.
my lord. We have to gather materials. Kindly. Can it be, my lord, after 10th of May, any day, my lord, subject to my lord's convenience?
When counsel, respondent has submitted that these two writ appeals are preferred by the appellants, being agreed with the judgment passed by the learned single judge. He has submitted that. As a matter of fact, in item, in writ appeal number 43 of 2024,
My lord.
the appellant has preferred a writ appeal after seeking permission from this court. And in that writ appeal, counter on behalf of the respondent is to be filed. Therefore, some time may be granted to the counsel, to him to file the counter in writ appeal number 43 of 2024. Learned counsel appearing for the appellant in writ appeal number 43 of 2024 has no objection if time is granted to the counsel for the respondent. This after 4 weeks.
My lord, we have prayed for a fixed date, my lord. with
Why
respect.
fixed date? The registry will fix the date.
My lord, I'm so obliged.
Item 62.
My lord, on behalf of respondent number 1, today I have entered appearance, my lord. Today I have entered appearance on behalf of respondent number 1.
You are today only.
Yes, ma'am.
Why so late? It's a matter of 2024 only.
Yes, ma'am.
And who is the respondent number 4?
I'm appearing.
He is appearing on behalf of the respondent. What is the role of the respondent number 4?
Who is the executive officer, my lord? 1 to 4, I'm appearing, my lord.
And you are appearing for respondent number
1.
1.
Yes.
1 to 4, you are appearing.
No, one.
One.
In this appeal, your lordship, he is the
Appeal,
respondent number 1. 2 to 5, the official respondent.
2 to 5 is settled.
2 to 5, I am appearing.
Here in this case, your lordship, only the price bid of the respondent number 1 was considered by the learned single judge. But initially, the notice of acceptance of tender was issued in favor of the respondent number 1. That is 1/6/2023. But within the time, he failed to respond the notice, and accordingly, the notice was issued to the present appellant, your lordship. And in terms of that, the appellant complied the notice, and thereafter settlement was issued in favor of me.
My lord, paragraph 15 of the judgment.
You are appearing for Naimuddin.
Yes, my lord. Naimuddin.
Naimuddin, your lordship.
Naimuddin, the person who failed to respond to the notice to the department, and later on you approach this court.
Yes, ma'am. This honorable court directed to deposit the whole amount because,
Why?
but because in respect of the appellants, then it was defective on many counts. His paragraph 16.
This was not the observation of the learned signal judge.
Yes, ma'am. Paragraph 15, 13 and 15. Page 45.
But they are saying this pending is without any basis. Yes. Will adjourn only for a few days because it appears prima facie. Once you have not responded to the notice, even though if you have quoted higher price.
Yes,
How can you be allowed to?
But there is some reason, my lord, because
You don't have any right.
before completion
Even if it's bit defective, what is your right? You have not deposited the money despite the receipt of notice by your wife.
yes, my lord, my wife has received, but at that time I
Then the
was.
court has specifically said this argument of yours that you are not, you are not in receipt of the notice is not genuine.
Yes. Only 1 or 2 days delay, my
And
lord.
what is he was unwell on recovery from illness. What was the illness? Or accident? What happened?
No, 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 my lord.
Illness, headache, or what was the illness? Cold or what?
Illness was there at that time.
Fatty liver.
Fatty liver, maybe.
I'll file affidavit, my lord, on reopening that any day.
Like,
Now, the problem is that your lordship, the settlement period is up to 36/2024.
My lord,
that's
So-
right, but at least if his first appearance, then we have to grant some time.
he has already run the market for 5 months, and this is a military market, and honorable court held that the remaining period should be allowed to me, my lord, on the ground that I am the highest bidder.
What circumstances? Okay. Let me call Mr. So and so put in appearance on behalf of the respondent number
1, my lord.
1.
Yes.
Has submitted that some time may be granted to him to prepare the matter.
Yes.
Time frame for his granted list on 29th of April.
Highly of this.
Okay.